Your Lordship,
Lordship, may we
For non-prosecution. Mentioning for non-prosecution.
Your Lordship, may I be permitted to mention one matter for inclusion? Yesterday I have mentioned I was seeking leave for this matter. You asked me to file this matter before in the regular side, so I have done that. But the urgency in this matter is the vehicle which has been involved in this instant proceeding is it's the only source of income I have, so it has to be heard urgently, my lord.
Did you serve?
Yes, Lordship.
Who did you serve?
Uh, I have served them.
Them means who?
I have served the opposite sides.
Opposite side.
Yeah,
Who are the opposite sides?
Lordship, the opposite side over here is the ADM and
Who
superintendent.
did you serve?
So I have instruction that it has been served.
It will appear in the list, do not worry. Call the
Lordship,
list,
may I
please.
be permitted to mention a matter for inclusion? This is a contempt application.
Give.
in respect-
Yes, call the list.
My lord permits me a day's accommodation only.
You are for the
I am for the
Bank
bank.
of India. Bank of India.
Bank of India.
And Star House. What is this Star House? How many respondents are there? How many respondents are there? One.
Actually, both are the bank. One is the regional office and one is the
All right.
office, Lord.
What is the grievance?
Lord, grievance is that Lord, at 18 December 2024, they floated a tender for the architectural consultant. On 21st, my lord, since we are having the 3 years experience in this field and almost completed most of the big project of this country, my lord, we applied for that, my lord. On 23rd, they acknowledged that our bid was successfully applied, my lord. Thereafter, my lord, thereafter of 2 months, on 13th March 2025, my lord, they asked.
Your list of dates is the entire writ petition.
This is long list. Now, the short list update is also listed in this. Short list update also is there. Short list update is also there, my lord. First of all, the short list update.
The original tender issued in December. There is a corrigendum. The petitioner submitted application form.
Please, lord. That for the
Then-
extension of the date, my lord.
All right. Petitioner applied for such and such email. Bank rescheduled opening of financial bids. Me opened. Petitioner declared.
My lord, after completing
Bank
all the
requested
procedure, qualifying the technical bid,
email
financial bid was
sufficient
open,
to
and I was
do
declared
verification
L1. After declaring the annual, my lord, without giving any reason, after 2 months, they cancelled the same and order for the reinitiation of the tender, my lord.
And that was in July.
That was in July, my lord.
We are in the
But-
end of October.
And this matter was filed long before, but it could not be listed before in September. This was filed in September, my lord.
September means immediately prior to the vacation. You filed it
Yes,
from
please.
July. What were you doing?
My
The
lord, thereafter,
cancellation took place in July.
my lord, thereafter we
All
get
right. Take instruction.
My lord, I have taken instructions, my lord.
Yes.
It has been cancelled due to some technical reasons. There were 6 bidders, my lord. We have informed all the bidders
All right.
that we are cancelling. You can participate in the new tendering process.
Right.
This is the communications that we have made also to the petitioner
Right.
that we are cancelling this tender
Hmm.
and we are floating a new tender. You can
my
come
lord,
and
cancelled
participate.
on the basis only the
On technical reasons,
there
My lord,
is no
Just wait.
To the technical reason. My lord, kindly cease this. I am
Yes.
perhaps covered by this decision, my lord. A very recent decision, Suresh Matthew, my lord.
Hmm.
Kindly cease, my lord. I will not trouble you much. Kindly see paragraph 20, my lord. Kindly cease paragraph 20.
No right accrues in favor of the person who
no.
participated in the tender process.
Yes, my lord, it is noteworthy that the order dated, my lord, kindly cease paragraph 20.
Paragraph 20. Yes.
Squarely covered by this. It is
Hmm.
noteworthy that the order dated 12th October 2022 is an order issued by the DFO, who is the competent authority. That is the order of setting aside. The setting
Yes,
aside
yes.
of this order of DFO, order dated 12th October 2020, is the order cancelling the earlier tender and issuing notification for retendering. My lord, the setting aside of this order of DA.
Well, I have followed it. Tell me, where is your infringement of the right?
Milord, the first thing, kindly see page 223, Milord. The
223.
213, Milord.
Tell me your legal right. How has it been infringed?
Milord, first up, I am declared the 11, Milord.
Yes.
First up, I qualified the technical bit. Before qualifying the technical bit, they have inspected the two sites according to them. They are satisfied with that. They declared with the technically bit okay. Thereafter, they opened the financial bit. After opening the financial bit, I was found L1, Milord.
No, they admitted you are L1, but due to technical reasons, they have cancelled it.
That so far the technical reason is that is not sufficient. They should give the reason. And kindly see page 213, Milord. What they have said. Kindly see page 213. There are many judgments of this court and Supreme Court, Milord.
Yes.
There's the fairness and
Yes, absolutely. Maintaining fairness,
that is not.
they will give you a chance to participate in the next tender process.
That is a different thing, Lord. So far, the cancellation is concerned, they should be very fair. Their action is arbitrarious, malafide, and you kindly see page 213, Lord. Please take the reference to your so and so on the captioned work in which you have participated. In this connection, it is to be informed that due to some technical reason, Lord.
Yes, please come.
My lord, sorry, my lord, I have given my copy to my lord. Was that judgment's copy?
The petitioner is aggrieved by the cancellation of the tender process in which it participated and was found to be the L1 bidder. Stop. The fact regarding the cancellation was communicated to the petitioner by a communicating letter dated July 22, 2025. Stop. The letter of cancellation mentions that due to some technical reasons in the tender, the bank has decided to go for re-tendering for the same. Stop. The information will be published in the newspaper, bank's website and MSTC space e-tendering portal. Stop. Paragraph. Learned advocate for the petitioner submits that the cancellation is mala fide, arbitrary and bad in law. Stop. According to the petitioners, the authority inspected the site in question twice.
That
And-
is question. The site which we have already completed. That was their wish to inspect two sites. They have inspected and they were
Inspected
satisfied
the
with that.
sites in question and were satisfied with the performance of the petitioner. Stop. After declaring the petitioner as the L1 bidder, the authority ought not to have cancelled the tender process. Stop. Learned advocate representing the bank submits upon instruction that the the tender process was cancelled because of technical reasons. Stop. The fact of cancellation has been made known to all the participants. Stop. The participants have been intimated that they would be at liberty to participate in the next tender that will be floated for the floated. Stop. The learned counsel for the respondents relies on the decision delivered by the Honorable Supreme Court in the matter of Principal Chief Conservator of Forest and others versus Suresh Matthew and others. Reported in 2025 SCC Online SC 933, paragraph 20.
'20 and '21, my lord.
At the 20 and 21.
वो judgment जिसमें we didn't put it.
Where is the notice inviting tender?
My lord. It starts from page 19 onwards.
19. And is there any clause for cancellation?
Page 21, my lord, kindly see page 21, similar clauses. Thus,
21.
Bank of India reserves the right, my lord. Page 21, last paragraph.
Yes.
Bank of India reserves the right to select or reject any or all the applications received without any reasons whatsoever.
No, regarding cancellation. Regarding cancellation.
Milord, this
Well,
is the,
rejection is
Milord,
fair.
this is the formal line that is mentioned always
Rejection of
every
all-
tender, Milord.
Rejection of all applications is equivalent to cancellation of the tender process, my lord.
The council refers to the clause mentioned in the form for application
बहुत समझ रहा हूँ.
in the e-tendering process, wherein it has been mentioned that the bank reserves the right to select or reject any or all the applications received without any reasons whatsoever. It has been submitted that because of technical reasons, despite selection of the L1 bidder, the bank was compelled to cancel the entire tender process. It has been submitted that the petitioner will get the opportunity to participate in the tender process once the same is floated again. Upon hearing the
My lord, my instruction is that it has been floated again.
Oh, it
He has
has.
not participated.
Milord, kindly, I'm giving one
When
statement
was
to
it
Supreme Court,
floated?
Milord.
My lord, today is the date of opening. That is my
Opening?
opening of that.
Milord, there is one judgment of the Supreme Court where it has been clearly stated if without giving reasons tender is cancelled, court interference is necessary, Milord. Kindly see. Para 14.
All right, give.
Yes.
এই লাস্টের লাইনটা কাটুন তো টেন্ডার প্রসেস এর জায়গাটা পার্টিসিপেটর এটা কাটুন লার্নেড অ্যাডভোকেট ফর দ্য পিটিশনার এই প্যারাগ্রাফটা কোথায় ঢুকবে আমি পরে বলে দেবো আপনি লিখে দিন লার্নেড অ্যাডভোকেট ফর দ্য পিটিশনার relies on the this is not the Supreme Court decision, this is the Cuttack High Court decision. Orissa.
No, this is the one.
Orissa High Court.
Sorry, kindly see para 14, Milord.
Here para 14.
Para 14, kindly see.
Yes. You just now mentioned there is a Supreme Court decision. Which decision are you relying on?
Sorry, Milord. Kindly see the Supreme Court.
Yes, please give.
तो ये वाला दीजिए
Yes. Which paragraph?
23
Para 123, Milord. Sanctity of the public-private partnership tender, Milord. Before we close to judgment, we must also address one very important aspect as regard the importance of the maintaining the sanctity of the tender in public-private tender. Milord, kindly come to the next page, Milord. 125, Milord. 125. The public interests are designed to provide a legal playing field. All the potential bidder fostering an environment where the completion thrives and the best value is obtained for the public. Not para 127 is very important, but sanctity of the contract is fundamental principle that underpins the stability and predictability of the legal and commercial relationship. When the public authority enter into the contract, they create legitimate.
1 minute. Enters into contract. You have not reached that stage.
Lord, I've not this date, but so far declaring the volume is concerned.
Sir, you have to find
Right.
out a judgment which fits to your case.
Lord,
So how does it fit in your
kindly
case?
see the ratio applied in this case. Lord, kindly see the ratio.
No, that ratio is different. আচ্ছা, আপনি বলুন তো। Learned advocate for the petitioner
Lord,
relies on the
it is
judgment delivered by the
specifically
Honorable
mentioned that
Supreme Court.
arbitrarily or unreasonably termination undermine these expectations and erode the trust.
The matter of
There, my lord.
Shubodh Kumar Singh Rathod, copy the cause title, reported in 2024 SCC Online SC 1682, paragraphs 123, 125 and 127. it has been submitted that the public authority ought to maintain the sanctity of tenders in public-private procurement processes. Stop. The sanctity of the contracts is a fundamental principle. Public tenders are designed to provide a level playing field for all potential bidders. Stop. The integrity of the process ensures that public projects and services are delivered efficiently and effectively, benefiting the society at large. Stop. Special reliance has been placed on the observation of the Honorable Supreme Court, mentioning that when public authorities enter into contracts, they create legitimate expectations that the state will honor its obligations. Stop. Arbitrary and unreasonable terminations undermine these expectations and erode the trust of private players from the public procurement processes and tenders. Paragraph. Learned advocate for the bank submits that retender was floated,
My lord, I want
but
to
the
cite one more
but the
judgment.
petitioner did not participate in the same. Stop. Today, bracketed date is the date for opening of the bids. Yes, sir. Next.
My lord, one more judgment that is very important. This is the judgment of the Cuttack High Court, para 14.
Sri Ganesh Construction.
No, my lord. This is the Mahan, the Tilka Logistic, my lord.
Yes. Yes.
Para 14, page 16.
Yes.
In view of the aforesaid fact and circumstance, this court of the considered view that by way of the subsequent explanation given by the counter affidavit and the communication dated so and so, cancelling the tender in question without assigning in the region cannot sustain in the eye of law. More so, in view of the Central Vigilance Commission guideline dated so and so, the tender accepting authority is not free to take any decision in arbitrary manner and is bound to regard clear and logical reason for any such action of the rejection, recall of the tender on the file. In view of the such position, in absence of the any reason communicated to the petitioner, the order so passed in so and so cannot sustain.
Yes.
There,
Please take down. Reliance has also been placed on the judgment delivered by the Honorable High Court of Orissa at Cuttack in WP within brackets C number 5272 of 2017. Date ta diye din 8 September 2017. Wherein the court was of the opinion that in view of the Central Vigilance Commission guidelines,
yes, my lord.
the tender accepting authority is not free to take any decision in an arbitrary manner and is bound to record clear and logical reasons for any action of rejection/recall of tenders.
Reason देना जरूरी है.
I have heard the submission made on behalf of both the parties and have placed and have perused the documents placed before the court. Stop. Admittedly, in the instant case, the petitioner was communicated the reason for cancellation of the tender process. Stop. The authority found that there were technical defects in the tender and cancelled the same
They have not
with
said
a decision
they have not said
to
technical.
re-tender the same. Stop. The petitioner participated in the initial tender process, but for reasons best known, did not participate in the re-tender process. Stop. The the mere arriving at a decision that the petitioner is the L1 bidder did not create any right in favor of the petitioner for execution of the contract in between the parties. Stop. The had the contract been executed between the petitioner and the authority, and thereafter the same been cancelled without assigning any reason, comma, then the ratio laid down by the Honorable Supreme Court
Milord, I would like
in
to
the matter
Milord,
of
I will place the CBC guideline, Milord, that is
in the matter of Subodh Kumar Singh Rathod, comma, as relied upon by the petitioner, would have been applicable. Stuff. In Subodh within bracket Supra, ekhaneo Supra likhe deben, the court clearly laid down that when public authorities enter into contracts, the state ought to honor its obligations. Stop. In the instant case, the stage of entering into the contract between the parties did not arise at all. Stop. It was merely after the opening of the bid that the petitioner was found to be the L1 bidder. Stop. Thereafter, the bank detected technical errors and cancelled the entire tender process. Stop. The bank also went to the extent of communicating the fact of cancellation of the tender process to all the participants. Stop. The in within bracket Sikal Logistics Limited. এখানে যে কাটাকেটটা বললাম না তার কস্ট টাইটেলটা লিখে দেবেন comma Supra, the court observed that there was an obligation for recording clear and logical reasons for rejection/recall of tender in accordance with the Central Vigilance Commission guidelines. Stop. In the instant case, reason within single quotes, not reason, likhun the ground for cancellation of the tender process within quotes, technical reasons, comma, was communicated to all the participants.
Milord, technical reason
Stop.
without giving any nature.
The Honorable Supreme Court, paragraph D, in the matter of Suresh Matthew within brackets Supra, laid down that fair opportunity to be given to all the bidders so that there would be a fair opportunity and equal opportunity, so that there would be fair play between them. Stop. In the instant case, all the participants were intimated
CBC
about
guidelines
the
also mentioned, Milord, that is kindly see for
about the reason for cancellation of the tender process, and everybody had the opportunity to participate in the retendering process. Stop. Next. The court is
Milord, kindly see
not
the CBC
convinced
this should be also
that
mentioned.
any legal right, far less constitutional right of the petitioner has been infringed by the act of the respondent authority in any manner whatsoever. Stop. The writ petition accordingly fails and is hereby dismissed.
Milord, kindly see the CBC guide, that is clearly that should be also mentioned in the judgment, Milord. Kindly see the CBC guideline.
Call the next matter, please.
Let's show for the petition.
Yes.
What happened in this matter, Lordship? The deed of conveyance was placed for registration 29 January 2007.
Yes.
Thereafter, Lordship, they kept pending that registration deed, Lordship. We have paid the money, set for the money, and IGR was issued in favor of the petitioner, Lordship.
Hmm.
As they kept themselves quiet, Lordship, we have made one representation. Lordship, kindly turn the representation, Lordship, first. Page 120, Lordship.
Yes.
To the additional register of assurance 15 Government Place East. This is to represent you that the above deed was executed before you on 29 January 2007 after payment of the entire stamp duty and registration fees payable thereupon, and that upon being satisfied you admitted the aforesaid document. However, when we went to collect the deed, to our utter surprise, we came to learn that you have marked the same as pending. Lordship, the word pending, Lordship, not disputed. That in spite of repeated requests and reminders, you have failed to complete the registration of the deed by complying with all legal formalities and handover of the deed. We therefore request you to kindly consider our representation and complete the registration of the aforesaid document by accepting the set for the value mentioned in the deed of conveyance dated 29 January 2007 and hand over the same to us immediately, Lordship. Lordship, as they kept themselves quiet,
1 minute. This is 29 January 2007.
Lordship,
This
no,
Lordship,
29 January 2007, Lordship.
the date when you put in the document for registration.
Lordship.
And this page 120 is dated 18th March 2024.
24.
So from 27 to 24, there was no
Lordship, I have mentioned
communication
that
from
I
your
have
side.
mentioned you that we came to learn, we went there and they being decided you admit the opposite document. However, when we went to collect the deed to our utter we came to learn that you have marked the same as pending. In spite of repeated requests and reminders, you have failed to complete the registration.
Where are the reminders, written
Lordship,
reminders?
that is not there.
So this is the first communication from
Lordship,
2007 to 2014, nothing in between.
Lordship,
24. Yes.
another way, Lordship, they kept themselves mum from 2007. They also kept themselves mum, Lordship. Lordship, now we have challenged the, we have moved with the Honorable High Court, Lordship. Page 128. Start with 125, Lordship. 128.
Yes.
None appear for the respondent despite service. Learned counsel for the petitioner submits the, although the petitioner have, Lordship, the facts narrate. Next page, Lordship. WPO number suggests dispose of directing the respondent 5, that is the additional register of assurance 1, Kolkata, to decide on the representation given by the petitioner dated March 18, 2024, annexed at page 87 of the writ petition in
Consideration of representation. Yes.
and Lordship, as they did not consider,
Right.
we moved contempt application, Lordship.
All right.
And the contempt order, Lordship, page 124, I think. 135, Lord. And order at
140 it starts.
140 order.
Yes.
The affidavit of compliance filed by the alleged contemptor and the affidavit in opposition filed by the petitioner is kept with the records. Landed council placed reliance on the said representation dated March 8 to 9 page 87, where the petitioner stated that the alleged contemptor was requested to consider the representative of the petition and complete the registration of the documents by accepting the set for the value mentioned in the deed of conveyance dated 20 January 2007 and hand over the same to the petitioner immediately. It is submitted that the fresh assessment does not deflect the position of the law as they have during contempt petition pending. So they have came with a fresh assessment, Lordship. Several documents which were also produced by the petitioner. Upon hearing learned counsel of the parties, I find that in order under contempt, the alleged contemptor was directed to decide on the representation given by the petitioner such and such in accordance with law. Upon giving an opportunity of hearing the petitioner as expeditiously as possible, possibly within the weeks from the date of communication of the order of the alleged contemptor. Although admitted the order has not been complied with in time, I find from the submission parties that hearing was given to the petitioner, including an opportunity to furnish documents relied on by the parties. Lordship, I am skipping that paragraph. Lordship, last paragraph. Be that as it may, it is beyond the jurisdiction of the contempt court to enter.
Yes, the court did not enter and would given you liberty to challenge the assessment in accordance with
Lordship,
law.
I have challenged.
This is the challenge.
Lordship, I have challenged it. Lordship.
21st November 2024, show me.
Lordship, fresh assessment order. Lordship, page 131. Has Lordship got it?
1 minute.
One 31.
Yes.
Address to Santosh Kumar Dalmia, the petitioner, one of the petitioner, petitioner number 1.
So this is the impugned order.
Lordship,
Yes.
I would like to inform you that as per advice of the Registrar of Assurance, Kolkata, the undersigned has assessed the market value of the property which has been transferred by the deed mentioned above. The market value required stamp duty and registration fee is given below. They have given the market value and stamp duty. Lordship, they have not given any reason or the basis of such calculation, Lordship. They have not given anything, which is mandatory as per law, Lordship, I shall show. It may be noted that the division stamp duty and registration fee has given it is deposited within the 1 month from the date of receipt of this notice. Otherwise, that expired of the stipulated period, the case may be forwarded to the collector for taking necessary action as per the provision of the section 47A of the Indian Stamp Act.
Hmm.
Lordship, this is the order which I have challenged, Lordship.
Hmm.
I shall show, Lordship, some provision of law.
Yes, please.
It's a pure question of law, Lordship. Lordship, kindly stamp act. Lordship, stamp. Lordship, section 33. I'm sorry, Lordship, I have to.
Yes.
Exemption and impounding of instruments.
Examination.
Sorry, examination and impounding of instruments.
Hmm.
Every person having, by law or consent of parties, authority to receive evidence, and every person in charge of public office except an officer of police before whom any instrument chargeable in his opinion with duty is produced or comes in the performance of this function shall, if it is appeared to him that such instrument is not duly stamped, impound the same. Lordship, I am relying West Bengal Amendment, Lordship, 4 and 5.
Hmm. Yes.
Lordship. No, no, 4 and 5. Have you Lordship got it?
No, West Bengal amendment is
Lordship,
not here.
Lordship, can you see? I have.
Yes.
Where deficiency in stamp duty is noticed from the copy of any instrument, the collector may suo motu or on a reference from any court or from the commissioner of division or from any office authorized by the Board of Revenue in that behalf call for the original instrument for the purpose of satisfying himself as to the adequacy of the duty paid thereon, and the instrument so produced before the collector shall be deemed to have been produced or come before him in performance of his function. In case of instrument is not produced within the period specified by the collector, he may require payment of deficit stamp duty, if any, together with penalty under section 40 of the copy of the instrument. That's provides important. Provided that no action under this subsection shall be taken after a period of 4 years from the date of execution of the instrument.
Hmm. Hmm. Yes.
And Lordship, now turn Lordship 47.
33 দেখালে তো
30. ওই West Bengal amendment. So it's 47 capital A.
Yes.
Lordship, heading is instrument of conveyance, etc. undervalued. How to be dealt with? Lordship, 2, Lordship, English 2.
Hmm.
Has your Lordship got it?
Yes.
Where the market value of the property, which is the subject matter of an instrument, has been ascertained and the proper duty chargeable thereon has been computed under subsection 1, the registering officer shall in the manner prescribed, send to the concerned person a notice calling upon him to make payment of the deficit amount of stamp duty within such time as may prescribed, and if such person makes payment of such deficit stamp duty in the prescribed manner, the registering officer shall register the instrument, Lordship. Lordship, this is the duty of the registering officer. And Lordship, thereafter, Lordship, 8 small a.
Yes.
The authority referred to in subsection 3 may, on receipt of any information or otherwise, suo motu, within 5 years from the date of registration of an instrument where such instrument was registered on the basis of the market value which was set forth in the instrument, or which is ascertained by the registering officer referred to in subsection 1, call for, examine any such instrument and any other documents relating thereto for the purpose of satisfying himself as to the correctness of the market value of the property which is the subject matter of such instrument and which is set forth in the instrument, or which was ascertained subsection 2 of the stamp duty payable thereon. Lordship, here 5 years, and as per collector's power, 4-year time has been mentioned, Lordship. This is a mandatory, Lordship. I shall show, Lordship, that is, this is the mandatory, Lordship. And Lordship, now I shall show, Lordship, the Registration Act.
Yes.
Lordship, 52, Lordship.
52.
52 section.
Section 52.
May, Mr. Your Lordship.
1 minute. Yes, 52.
Duties of registering officers when document presented.
Yes.
The day, hour, and place of presentation, the photographs and fingerprints affixed under section 32A, and the signature of every person presenting a document for registration shall be endorsed on every such documents at the time of presenting it. A receipt of such document shall be given by the registering officer to the person presenting the same, and subject to the provision contained in section 62, every document admitted to registration shall, without unnecessary delay, be copied in the book appropriated therefor, according to the order of its administration. All such books shall be authenticated at such intervals and in such manner from time to time prescribed in the Inspector General. So it is the duty of the registering officer, Lordship. Lordship, now turn, Lordship, page section 52, 61. Lordship. Endorsements and certificate to be copied and document returned. The endorsement and certificate referred to and mentioned in section 59 and 60 shall thereupon be copied into the margin of the register book, and the copy of the map or plan, if any, mentioned in section 21 shall be filled in book number 1. The registration of the document shall thereupon be deemed complete, and the document shall then be returned to the person who presented the same for registration, or to such other person as is nominated in writing in that behalf on the receipt of mention in section 52. And Lordship, last Lordship, section 71 and 72. Has your Lordship got it?
Yes.
Every sub-registrar refusing to register a document except on the ground that the property to which it relates is not situated within his sub-district shall make an order of refusal and record his reason for such order in his book number 2 and endorse the word registration refused. Nothing is there, Lordship. They kept silent over that registration deed. When I approached the court, made representation, they did not answer. When approached the court, initially they did not appear. Contempt, first time they did not appear, rule was issued, and thereafter they come with a new assessment. And Lordship, that is, your Lordship has seen that only assessment. Where from they came, the amount come, and what is the basis, nothing has been stated. And there is no documents that they have, registration has been refused, no documents is there. Lordship, I shall show Lordship few judgments, Lordship. And Lordship, their contention is that, Lord, what falls from Lordship first, that what I was doing, I kept myself mum, and they just shrug up their responsibility and try to shift it to me, that I have not approached. So I have to approach court prior to that to get the registered deed. This is their contention. Lordship, I am relying on judgment, Lordship, Supreme Court, Lordship. এটারই কপি দিতে পারছি, অন্যগুলির কপি নেই। Lordship, these appeals are at the instance of the Chief Revenue Controlling Officer come the Inspector General of Registration and two others revenue officer, seeking to challenge the judgment and order passed by the High Court of Judiciary of Madras dated such and such, respectively, by which the High Court allow the civil miscellaneous appeal filed by the respondent herein. Lordship, this appellant is Chief Revenue Controller and the private party is the respondent, Lordship. Under section 47(a)(10) of the Indian Stamp Act, for short the Stamp Act, and thereby quashed and set aside the order passed by the Chief Revenue Controlling Officer come the Inspector General of Registration with respect to the stamp valuation. The subject matter of the litigation is that valuation shown the two sale deed registered such and such respectively. The respondent herein is a purchaser. He got the two sale deeds executed through the original owner of the property in question. The market value of the entire property covered in both the sale deed, which is rupees 1,20,000, 1,30,000 respectively. It appears that the joint sub-registrar Tindivanam, on receipt of the two registered sale deed, declined to release the documents on the premise that the sale consideration shown in the two sale deed was undervalued. Lordship, in this case, it was given reason that it is undervalued, so he refused. But my case, Lordship, refusal is not there. The matter was accordingly referred by the joint sub-registrar to the special duty collector stamp under section 47(a)(10) of the Act for the purpose of determining the correct market value of the property. It also issued notice in Form I fixing the value such and such. The special duty collector, on conclusion of the inquiry, fixed the market value of the property covered under such and such 10,36,936, 51,16,600. The respondent herein being dissatisfied with the order passed by the special duty collector, preferred a statutory appeal before the Inspector General of Registration. The appeal came to be dismissed. In such circumstances referred to above, the respondent herein went before the High Court by filing civil miscellaneous appeal under section 47(a)(10) of the Stamp Act. The High Court allowed both the appeals and thereby quashed and set aside the order passed by the authorities below. The appellant, feeling dissatisfied with the impugned judgment, the order passed by the High Court, have come before this honorable court. Lordship, para 12, Lordship, the Supreme Court has quoted the High Court order. Para 12, Lordship. That being the legal position, if the contention raised.
Do not read the whole thing. Show me
Lordship, Lordship, para 12, Lordship, last 4 lines, Lordship. Demanding additional stamp duty on the basis of such exorbitant value fixed is hence arbitrary, bad in law and null and void. Lordship, just to come, Lordship, just from 3rd line, 4th line, in the absence of one such materials, Lordship. Lordship, para 12, Lordship.
Yes, yes.
Lordship, furthermore, no materials is made available to show that the third respondent registering officer, on the basis of such material, arrived at the conclusion that the true value is not set forth in the document. In the absence of one such material, the proceeding initiated under section 47 is illegally unsustainable. As such, the proceedings initiated for determining of the market value and the outcome of such proceedings fixing the market value of the property covered under this document such and such, and demanding additional stamp duty on the basis of such exorbitant value fixed is arbitrary, bad in law, and null and void. This was the observation of the Calcutta of the High Court, Lordship. Lordship kindly concluded the High Court, para 13. Thus, the discussion held above would only reveal that the determination of the market value of the property in question is in pursuance of the reference made by the third respondent registering authority under section 47A of the Stamp Act, without following the procedure laid down under the Act and without performing the statutory obligation cast upon the third respondent, and the input orders of the respondent 1 and 2 is enhancing the market value and demanding the additional stamp duty based enhancement, and without any basis and based on irrelevant consideration and assumption and presumption and without application of mind. Further, as one has proved, to prove that the instrument was undervalued is on the department and the same has not been satisfactorily discharged by the respondents, the impugned order of the respondent are liable to be set aside. Para 14. Thus, what waited with the High Court is the fact that the form I noticed failed to assign any reason as to why the documents could be said to be undervalued. In other words, what was the basis for the special duty collector to say that the consideration shown in the two sale deeds was not correct? According to the High Court, there was no basis of any irrelevant materials on record to take the view that the two documents were undervalued except and spot inquiry and local inspection. Lordship, I am skipping Lordship. I am coming to the observation of the Supreme Court, para 18, Lordship. Under section 47A1 and under section 47A3, if the registering authority has reason to believe that the instrument of conveyance did not reflect the correct market value of the property, then the registering authority has the power to refer the same to the collector for determining of market value of the property, and the collector, on reference under section 47A1, may determine the market value of such property in accordance with law, the procedure prescribed. So, Lordship, the controller has the power for 4 years. Lordship. The determination of market value without notice of hearing upon the party is liable to be set aside when the registering authority finds that the value set forth in an instrument was less than the minimum value determined in the accordance with the rule. In that event, the registering authority is empowered to refer the instrument to the collector for determining of market value of such property and the stamp duty payable thereon. When both the authorities, why is the Lordship, I am skipping that para, Lordship, para 21. It has been rightly held in the case of Moheli Club for the state of Punjab reported in such and such, that the registering officer after registration of the document can defer the same for adjudication before the collector if he has reason to believe that there was deliberate undervaluation of the property. Such a deference is not a mechanical act, but the registering officer should have a basis for coming to prima facie finding of undervaluation of the property. Duty is enjoined upon the registering officer to ensure that section 47A1 does not work as engine of operation, not as a matter of routine, mechanically, without application of mind as to the existence of any material or reason to believe that the fraudulent intention to evade payment of proper stamp duty. The expression reason to believe is not synonymous with subjective satisfaction of officer. The belief must be held in good faith. It cannot be merely a pretense. It is open to the court to examine the question whether the reason for the belief must have a rational connection or
You can skip that portion also then.
Lordship.
Then
para 25, Lordship. 25, 26.
hmm,
It appears that High Court followed its full bench decision. Lordship, full bench observation has been quoted, para 26.
hmm.
Full bench observation, Lordship. Lordship, may I read it? Full bench observation, Lordship.
Registration is a sine qua non, but then here registration did not take place.
Registration of a document is a sine qua non for referring the matter to the collector. If the registering officer believes that the property is undervalued, no jurisdiction has been conferred on the registering officer to refuse registration, even if the document is undervalued. Besides, there is no authority for him to call upon the person concerned to pay additional stamp duty. Collector is the prescribed authority to determine the market value. After affording a reasonable opportunity of hearing the parties, the registering officer cannot make a roving inquiry to ascertain the correct market value of the property by examining the parties. However, it is expected that he has to give reason for his conclusion for undervaluation. However short they may be, he can neither delay nor refuse registration of the instrument merely because the document does not reflect the real market value of the property. In order to reach a conclusion, there is no bar for the registering officer to gather information from other sources, including official or public record. Valuation guidelines prepared by the deputy official periodically are intended with an avoid object of assisting the registering officer to find one prima facie whether the market value set out in the instrument has been set forth correctly. Next, Lordship. When the collector exercises power under subsection 2 and 3, he shall be deemed to be a quasi-judicial authority, as a detailed procedure prescribed in the relevant rules evidently portrays that the collector decision is relatable and verifiable by making an inquiry after hearing the parties concerned. The collector has been conferred with such powers by the statute, whereas the registering authority is not. The powers of the registering officer are demarcably limited, that is to say, he cannot at all hold any inquiry to ascertain the quantum of stamp duty payable on one instrument. As adverted to supra, we shall not undertake a detailed inquiry by examining the parties, which powers are accessible by the collector alone. The relevant rules would.
Yes, I've read this.
Lordship. Para 27, Lordship.
Yes, I've read.
Lordship.
27 I have read.
Lordship.
31 I have read.
And Lordship, concluding Lordship, appeals fail, hereby dismissed.
Mm.
So, Lordship, I am challenging the power, I am challenging the jurisdiction of the registry officer. And Supreme Court has exactly pointed out that.
Oh, where is the undervaluation rules, prevention of undervaluation rules of this state?
Lordship, I have shown that, Lordship.
No, is there a separate rule
No, there is no separate.
akin to the 1968 rule that was taken into consideration there?
2001 rules is
That is
there is part of the
Yes.
itself.
That is part of it.
West Bengal
That is part of-
statute is also different, 47A is different,
Not-
rule is also different.
But the
Yes.
ratio of the judgment, Lordship.
No, I've followed prevention
It
of
is not
undervaluation
based on the
rules is there.
guiding statute. The statute is
2001.
different.
It was put to registration 2007. All right, yes.
Lordship has got the rules, Lord.
Yes, it's here. Would you like to submit anything more?
Lordship, I want,
In that case, we'll continue on the next day.
Lordship.
It's already 12. When would you like to come back?
Any day, Lordship, fix.
And is the state's opposition there on record?
Lordship, I have filed a report, my lord.
All right.
We have filed
Report has
exception.
been filed, my lord. That is the
And
document.
an exception has also been filed. Very well. We'll continue it tomorrow.
Lordship.
Please come. The petitioner commences argument but does not conclude the same. List for hearing tomorrow. No further matter.
That's 1.628. Don't get up there.
Look, this is appearing at our request. We had mentioned the matter. Your Lordship had been pleased to pass an order on 24th of October 2025.
Yes.
I'm assuming that my learned friend did not know about this. This was seeking an implementation of an order
You are for the private respondent.
Private respondent.
6 to 8.
6 to 8, the SURFACE applicant before the Debt Recovery Tribunal.
All right.
This writ is for implementation of an order
Hmm.
which has passed or lapsed its period under section 14.
Hmm.
My lord was pleased to pass an order on 24th October 2025.
Right.
We were not present, my lord, it was our mistake. We should have brought to your lordship's attention that on 9th September 2025, the Debt Recovery Tribunal had stayed the operation of that order.
And the bank was not made aware?
Bank was
The bank
also
was aware?
I was the petitioner, but the bank was the petitioner.
Yes, you were not
It was
aware.
filed in the it was filed in the month of July, Millard.
bank was present in DRT.
Yes, the order of the
Communicate.
DRT was not known to you.
Probably he did not.
All right, give.
I'll just give the DRT.
Please come.
9th of September order. I have a copy now.
The writ petition has appeared in the list on mentioning by the learned advocate representing the respondent numbers,
6 to 8.
private respondent.
Private.
Respondents numbers 6 to 8.
Yes,
Not 9,
6 to 8, not 9.
6 to 8. It has been submitted that the order dated 24th October 2025 disposing of the writ petition,
Yes.
passing direction upon the District Magistrate North 24 Parganas for enforcing the order passed on January 18, 2025 was passed without taking into consideration the order passed by the Learned Debts Recovery Tribunal Roman 1 Kolkata on 9th September 2025 in case number SA 335/2022. পার্টির নামটা লিখে নেবেন তো ঠিক আছে Stop. In which portion is that stay recorded?
The last page, your lordship will find. Last page. II.
To take possession of the secured asset on the
Yes.
basis of the order of the DM. Is the date of the order mentioned?
Is 9 September 2025.
Where is it mentioned?
Oh, I'm sorry, the date of this order,
DM's order?
20th January 2025.
20th January 2025, that your lordship will find the last.
DM's order 18th January, as you mentioned in your lordship's order, 18th to
18th minute.
But it will actually be
Where
20th.
is it reflected in the DRT's order?
Yeah, first page, last sentence.
20th January.
It will be 20th January.
But this order is 18th January.
There is only one DM order. That
Writ petition, page
28.
29 minute.
28 of the
29 of the writ petition, signed on 18th minute, just
Date
below
is
that is
20th.
20th. Page 29.
there is only one order, this I have personally checked.
William. It appears that the Learned Tribunal video order dated 9 September 2025 restrained the bank from taking possession of the secured asset on the basis of the order passed by the District Magistrate North 24 Parganas or any other measures till disposal of the securitization application. Stop paragraph. It has been brought to the notice of the court that the aforesaid order was not within the knowledge of the learned advocate representing the bank, for which the aforesaid order would not be placed before this court. Stop paragraph. On a perusal of the order of the Learned Tribunal, it appears that a securitization application at the instance of the borrowers is pending consideration before the tribunal and necessary order has been passed therein. Stop. Next. In view of the above, the order dated 24th October 2025 passed by the court, by this court, stands recalled. Stop. The parties are granted liberty to take steps before the Debts Recovery Tribunal where the proceeding under the SARFAESI Act is under challenge. Stop. The writ petition stands dismissed.
Great.
Much obliged.
May it please your lordship. My lord, this matter is appearing at my instance. I appear for the petitioner in this matter. By way of my lord's last order dated 3rd October 25, there's an interim order that is operating in my favor, restraining the respondents from relying upon or acting upon a demand notice under 13.2 pending disposal of the present petition, my lords, on affidavit. There's no reply affidavit that has been forthcoming by my learned friends yet, my lords.
What is the main case? Who are you representing?
Respondent number 1 and 2.
May I
1 and
just
2.
quickly
1 minute.
indicate what-
1 and 2 is the LIC Housing Finance Limited.
There was a direction to file affidavit of opposition on the reopening day of the vacation. But I am only seeking 2 weeks time to file my affidavit of opposition, my lord.
Will the writ petition be maintainable?
My lord, as on date, there's only a 13.2 that has been issued. I have no other recourse but to approach this honorable court, my lord.
Why 13.4 stage has not yet arisen?
13.3
And
is not yet
the
arisen.
13.3 is there?
13.3 is 13.3, my lords, will only arise. I'll give a representation.
Yes.
Basis which they'll proceed for a
Right.
petition notice. Only after that will the 17 be.
What is the error in 13.2?
13.2, I'll tell your lordship, my lords. I have purchased a scheduled property from the financial institution. Now what they have proceeded to do is that they've proceeded to issue a fresh demand notice on my property again.
I didn't get it.
I'll tell your lordship. They are trying to reinforce their security interest over a property that has already been sold under the aegis of SARFAESI Act. So
Already been sold.
yes, so I am the successful purchaser.
Yes.
2021, there's a valid sales certificate that is registered in my favor by LIC Housing Finance.
All right.
Now, after 4 years, they're coming again and pasting a 13.2 on the property in the name of the erstwhile borrower.
All right.
That
Will
is
you
the
annex the
summons.
sale certificate?
Yes, madam.
Show me, please.
Your lordship will kindly have page number 21 once, my lord.
What is page 56?
Page 56, my lord, is there's the same sales certificate. It's the same one that's at page 21.
All right. This is the same one.
Yes, my lord. And it's been registered if your lordship will have.
Yes. You
Page 31, your lordship will find.
you are
The
Manoj
e-challan.
Kumar Mishra.
Yes, my lord.
Authorized officer of LIC Housing Finance. Is it the same loan? Is there a separate loan?
My lord,
What is your stand?
my lord, if your lordship sees the sales certificate, my lord, the person representing the LIC in the sales certificate is not the person of the LIC. There is a fraud committed upon him by some Shri Arindam Nandi. If your lordship sees the order dated 3rd October, there is a direction to add.
1 minute. Arindam Nandi.
Yes, my lord. Sales certificate, my lord.
Secured credited through its authorized officer, Sri Arindam Nandi.
He's no one with the. He's not connected with LIC.
Not
He's
connected
not the
with
authorized
LIC.
No, no, he's not.
Since when? Was he ever the authorized
Never,
officer?
never. He's not the person of the LIC. I don't know who is Arindam Nandi. I have instructions from my client. There is a representation given to him before the writ petition was filed that has not been annexed. For that reason, my lord, supplementary affidavit was directed to be filed by them. That has not been filed. I'm not aware whether that has been filed or not. But my instruction is that LIC has never executed any such deed. My lord, this is a fraud committed upon him. For that, he has not taken any steps, my lord.
For the fraud, after detection of the fraud, what did you do?
My lord,
Did you serve respondent number 4, the added respondent?
Yes. So in terms of the last order, my lords,
Show me
the
the affidavit
respondent
of
number
service.
4 had
please.
to be made a party which we've carried out, and this is the affidavit of service in that regard, my lords.
Where are the track reports?
Has the R4 received it?
Mm,
When have you dispatched it? Perhaps the respondent number 4 has not received the amended petition yet.
27th, you've put it to post. All right. How soon can you come back with your you file a report by way of affidavit disclosing all facts, all right?
Because in the meantime, may the interim order be extended, my lord.
What is the interim order?
Your lordship will kindly have, my lords, paragraph 10 at page 2, internal.
Order of stay of the notice till or until further order, whichever is earlier. 28th October. Which page do I get that?
My lord, your lordship will have this at internal page 2 at paragraph 10, my lord.
No, the P3, which page?
P3, your lordship will have P3, my lords, at page 48, my lord, of my petition.
Sixth, the impugned order is of June, and you obtained the interim order during the vacation. So did not take any steps.
Because we taken leave
In terms of
lordship to move
13.3, prohibited from transfer. Loan account has been classified as NPA only in May 2025. What is the coercive steps that will be taken?
because they'll end up taking possession of the property, and I'll be, my lord,
Taking possession without 13.4.
13.4
Will
naturally,
they
well,
jump
as on-
steps?
I'll tell you, lordship, my lord, as on date 13.2
Please
has
come.
been issued, no subsequent step.
No subsequent steps.
And
It
I've
is in
been-
June. I am
because
not
I have-
extending the interim order. On the prayer of the learned advocate representing the respondents, comma. How soon can you come back?
My lord, 2 weeks.
Sir, order was passed on 3rd of October.
My lord.
You allege fraud and then you seek extension of time. You should have come up within 2 days.
The officer is not here, my lord. Only 1 week, my lord, in that case.
Office is not here. Where is the office?
And officer, the person authorized to sign this position is not here.
Somebody should take the responsibility.
In that case, my lord, your lordship passes 1 week's extension.
Here it's in the Chittaranjan Avenue. The office is here. You can get hold of some authorized officer to sign it.
I shall do that.
Until the final
Achha.
hearing, if your lordship could protect me, my lord.
Please wait. A fraud is said to be committed. So the court gets slow in passing interim orders or even for extending the
The
interim order.
petition was filed in August.
May I just make one
Leave was
submission?
taken on the
first?
last day.
কি বললাম? On the prayer of the learned advocate representing the respondent numbers 1 and 2. Time is granted till 7th November 2025 for filing a report by way of affidavit with copy upon the learned advocate representing the petitioner. Release the matter for further consideration on 17th November 2025. Stop. It will be open for the petitioner to file an exception to the report to be filed by the respondent numbers 1 and 2. Stop. Let further notice be served upon the non-appearing respondents communicating the order of the court. Stop. It will be open for the respondent numbers 3 and 4 to file their respective affidavits. Affidavit, not S. Affidavit. The as it appears that the impugned order was passed in June 2025 and no further steps have been taken by the respondents till date. Accordingly, the court is not inclined to extend the interim order issued by the vacation bench on 3rd October 2025.
But I have not been served with the copy of the amended date petition or the supplementary affidavit till date.
Where is the supplementary?
The supplementary, my lord, the lordship will kindly have it on record. I've already served it, is what's my instruction.
No,
in
my lord, I have not been served with the
by
copy.
courier. You just mail it and hand over a copy, right?
Well, I already filed my
The learned
I
counsel
just
is appearing.
hand over-
Yes, please do. Supplementary affidavit filed by the petitioner.
and the
today.
amended date petition, my lord.
Amended, the 2 names have been added. Just put it down in the cost title. Is taken on record. Stop. Let copy of the supplementary affidavit be served upon the non-appearing respondents. Yes, next.
My lord, may I just make one submission, my lord, your lordship? They are alleging fraud today against a registered sale certificate, my lords. So the onus is upon them to prove that fraud. And what step has he taken till date? to today show
I'll
that
also take
the
a
person
definite
is
point, my lord.
masquerading.
Let him file the report, then we will see.
Grateful.
Next.
May it please your leadership, I'm appearing for the petitioner. Come up at our instance, we had mentioned the matter. May I file the affidavit of service?
Respond number 7.
The facts very briefly.
1 minute, 1 minute. Reserve Bank is here. The State Bank, is the State Bank here? No.
We had served the State Bank. We have served everyone. The State Bank, after mentioning is hand
Commissioner of
service.
State Tax.
That we have served by
We have served by email because the writ was served. We filed the affidavit of service, and after mentioning, we have also served them by email because the office was closed. So we couldn't hand deliver.
Instructions to appear on behalf of the ICICI Bank Limited, but copy has not been served. That is what I saw.
We've served the copy by hand. That's there in the affidavit of service. We'll give another copy. But the answering respondents really are respondent numbers 1 to 4, Your Ladyship. I'll indicate why.
Who is representing the state?
Respondent 1 to 4 is the main answering.
Commissioner of State Tax.
Very simple facts. We've made a mistake and now we are not getting back the money.
Did you serve the GP's office?
GP's office, not in the GP's office.
If the GP is not served, then nobody is going to represent the state. The respondent numbers 1 and
The
2.
state is not a party. Respondent number 1 to 4.
Commissioner of State Tax.
Yes.
Somebody should appear.
The difficulty is the GP will not accept this service because it's a different department. If there's an order from Your Ladyship, then perhaps we'll be
Please
permitted
come.
to serve this.
The
Not I'm for the 8, 9 and 10.
8, 9 and 10.
10 and 11.
Yes, Bank.
The writ petition has been served on all the parties. It's only
I
post the
understand.
mentioning.
The
Even 1 to 4.
none represents the respondent numbers 1 to 4, whose presence is very much required for the purpose of effective adjudication of the instant list. Stop. Let a notice be served in the office of the government pleader, intimating that the matter will appear in the list on 4th November 2025. Stop. The respondent numbers 1 to 4 should be represented by the learned counsel on the adjourned date. Stop. The learned advocate representing the respondent numbers 1 and 4 shall come ready with all necessary instruction. Affidavits of service filed in court today be retained with the record. In the meantime, you also get a copy and take instructions. And the others who are present, come ready,
We'll
please.
serve right now. It can be recorded.
No. She will not deny. Why record all these things?
May it only retain its position.
It
Your
will
Ladyship.
retain.
I'm very deeply obliged. Very deeply.
1 to 4.
I was ready with my check to deposit my
Check for what?
The
Who are you giving the check?
service. Notice has been served that I want to repay the entire amount. Whatever they
Who
have,
is the authority?
the bank, Union Bank, Indian Bank, sorry.
Indian Bank. Who appears?
Yeah,
Anybody there online? Nobody is there.
May I serve another notice and come back tomorrow? Oh, yeah, we have given another notice to them that the matter will be appearing today. ওদের অ্যাবসেন্সে তো করা যাবে না।
Are you there?
And for the Union of India.
Union of India.
Union of India.
RTC application has been filed.
Yes, the bank's presence is required.
I'll intimate them and I'll come back tomorrow.
Let it retain its position. I'm not touching anything. You can check as to who appears for the Indian Bank so that the matter can be taken up. Not today only. 5 পেছনে এন্টি লিখে রাখবেন।
I appeal for the petitioner, madam.
Yes,
For the respondent number
And
2.
may I indicate that the matter was taken up, nobody appears, and so that
very well, that
Very
will
well, sir, yes,
indicate. Yes. State respondents,
My lord,
who are you
Number 2
representing?
and 3.
They are
my lord,
the,
I'm the tender issuing authority.
my lord, the West Bengal Mineral Trading Corporation,
yes,
the West Bengal Mineral Trading and
development.
development of that corporation has floated a tender for setting up an operation of checkpoints, and the petitioner participated in that tender, and the clarification and certain documents were sought for from the petitioner by the tendering authority. Petitioner submitted those documents within the time, but subsequently after that, the petitioner was after a long time, petitioner was intimated that this tender was rejected. A technical bit of the petitioner was rejected since the documents are incomplete. My lord, in the day after, my lord, this writ petition was filed. After this filing of this writ petition, the petitioner came to know that the successful tenders in the technical bid, they have filed certain fake and forged documents on the and challenging that a writ petition has already been filed. And
By somebody else.
somebody else.
All right.
So there an order has been passed for directing the authorities concerned to submit a report in the form of an affidavit, and the matter possibly will coming. So
Where? Before this bench?
no, and
Before
before the
some-
vacation, before the
The
vacation.
vacation bench.
Vacation bench.
Can you
Let-
show me a copy of that
My
order?
lord, that order, may I?
Yes,
Order was, I am on with that order.
Yes.
Order basis.
So what do you want?
My lord, may I come up with a affidavit supplementary so that I can also bring those facts to the records of this proceeding, and in the meantime, my lord, the further proceedings we stayed with regard to this tender. আপনি তো অ্যাপিয়ার করেছেন, ঠিক আপনি অ্যাপিয়ার করেছেন।
জজ সাহেব কে ছিলেন?
ওই পার্থসারথী সেন।
সেখানে কিছু তো অর্ডার হয়নি।
What is the stage of the tender now?
The
Work order has been issued.
Yes.
And did you consider the objections? Did you also
Yes,
give
my
some objection? Any consideration?
We
There
have
was no objection raised by him.
Not
He
by
have
him.
rejected his tender on the ground of non-submission of a document.
Incomplete documents, you
Incomplete
say.
Of attorney has not been submitted by him.
All right,
That is a mandatory requirement of the tender.
right.
That on that ground, the tender has been rejected.
Yes.
my lord, the documents, can you see, my lord, the documents sought for is does not speak of any power of attorney or something.
Please
of that kind. My lord, page number, my lord, kindly see, page number 124, annexure P2.
P2, yes. Yes,
He speaks of three documents, my lord.
yes.
My lord, one is the solvency certificate document to be submitted.
Hmm.
Solvency certificate issued by the scheduled commercial bank in the name of the bidder. Second one, my lord, is the work order, permission, or work done certificate issued by the competent government authority in the name of the bidder. And the third one, the legal metrology certificate from the weighbridge issued by the competent government authority in the name of the bidder. So these are the three documents that were being sought for, and those three documents along have been submitted before the authorities within the time that is prescribed in this letter. But no documents as it fell from my learned senior friend, but the power of attorney.
Show me your cancellation.
My lord, the cancellation is at
rejection
page.
Of tender.
It is a page at 150, page 150, annexure P4. It also does not speak of any power of attorney.
No, you were given opportunity to seek clarification. In case any clarification or feedback, you may contact. Did you contact the authority?
Yes, my lord. Clarification. I have submitted the clarification. My lord, annexure, the very next page, my lord, kindly see. Page, annexure P3, page 126. I've submitted all the documents that were sought for.
Page 151. Page
151, my lord, I have
1 minute. Where 150, where is the rejection you showed me just now?
rejection, my lord, at page
150.
150.
Right, 150 is dated 18 September 2025.
Yes, my lord.
On that day, you got to know that your technical evaluation stood rejected because of incomplete
Yes,
document
yes.
submitted by you.
Yes, my lord.
In that document itself, it is mentioned in case any clarification or feedback, you may contact.
Yes, my lord.
Did you contact
Yes,
the
my lord.
authority?
Yes, my lord. The very next page, my lord, kindly see. Page number 151.
18 September.
It's on the same date.
Hmm.
I specifically written.
All right. 151. After 151,
no.
there was no communication from their end. Yes, what is the incomplete document?
Lord, page 124
Yes.
has nothing to do, Lord, with the tender. I tell you, Lord, tender submitted by him. I tell your Lordship why. Please come to page 47. Lord, what had happened is, page 47, kindly take note of clause 5.3.4 and 5.3.5.
Yes.
5.3.4 says the bidder must have the solvency value of 50 lakhs at the time of bidding.
Hmm.
And 5.3.5 says that the bidder should have the following experience anytime during the preceding 5 financial years, etc.
Hmm.
Says experience in operating at least 2 checkpoints and experience in operating at least 2 weigh bridges. Now, Lord, what has happened in the tender, it was not mentioned that these solvency certificate would be obtained from whom, or Lord, these experience certificates from the checkpoints, operation of checkpoints, and Lord, the 2 weigh bridges, it will be obtained from whom. So, Lord, a clarification was required from all the bidders down the rank, not only the petitioner, but from all the bidders. If your Lordships kindly come to page 124, your Lordships will find this was clarified by saying that this solvency certificate should be from the scheduled commercial bank. This is one. Number 2 is that the toll points for
Yes,
this,
yes, I get it.
these are,
All
Lord,
right.
they have to obtain from
Clarifications.
the
All
authority.
right. All right.
This was submitted by all the bidders.
All right.
After that, when the evaluation stage came, it appears that they have not complied with the tender conditions. I tell your Lordship why.
Which tender condition?
I will just not come back to it. Please come to page 47, your Lordship was looking at.
Hmm.
Kindly, my Lord, take 5.4,
Yes.
which says participation through consortium.
Hmm.
Has your Lordship got that?
Yes.
Now, my Lord, this is a bid submitted by the petitioners in consortium.
All right.
Now, in consortium, your Lordships will kindly see that this is one of the terms of the consortium. Your Lordships may kindly come to page 51.
Yes.
No, sorry, 52.
Yes.
My mistake.
Right.
Kindly see 6.1.
Yes.
This is online submission of techno-commercial bid, then offline submission of documents. Has your Lordship got that? 6.2.
Yes.
Kindly, my Lord, see 6.2.2. In the first cover, bidder shall submit the following duly signed physical copies. Kindly see Annexure 1 format for power of attorney. Has your Lordship got that?
Yes, yes.
Kindly see page 63. This is the format in which the power of attorney has to be submitted. Now,
This has not been.
This has not been submitted by the petitioner.
All right.
So, my Lord, that is the deficiency in the document on which, my Lord, his cancellation has taken effect. And
The entire consortium goes.
Entire consortium goes because they have not submitted, my Lord, the power of attorney which is required to be submitted by the consortium.
Right.
My lord,
And your Lordship is kindly, your Lordship is looking at page 63.
Yes.
My learned friend is right, my Lord. I just want to point out, to be executed by the bidder, at the top, your Lordships will kindly see, after format, it says to be executed by the bidder, each member for consortium in case the bidder is a consortium on non-judicial stamp paper, etc. So, my Lord, this is the reason why the tender has been terminated. It has got nothing to do with those
Solvency certificate and all.
my lord, may I, my lord, my lord, may I? My lord, the fact that the power of attorney is wanting was one of the documents that is wanting in the proper format. That fact ought to have been intimated to the petitioner. My
I like to draw my lord's kind attention to clause 7.2.4 and 7.2.5 at page 58.
Yes.
Kindly see.
Yes.
It says, my lord,
Hmm.
7.2.4.
Hmm.
During the evaluation of the techno-commercial bid, the bid evaluation may, at his discretion, ask from the bidder for clarification in the techno-commercial line, including the documentary evidences supported by them for the purpose of meeting the eligibility criteria. The request for clarification shall be sent to the bidder in writing, and the request shall also be specify the timeline within which the bidder has to submit its clarification. Failing which the clarification may not be considered by the techno-commercial bid of the bidder may be evaluated by West Bengal TCL without any further reference. The committee will examine, 2.5, 7.2.5. The committee will examine each proposal based on the document submitted by the bidder. The committee may seek clarification from the bidder to clarify ambiguities and uncertainties in the bid. So it was well open to the
All right,
respondents
please come.
to call for clarifications from the petitioner.
Very well.
But they
The
did not.
petitioner participated in a tender process floated by the West Bengal Mineral Development and Trading Corporation Limited for selection of checkpoint operator for setting up and operating the checkpoints. Vide expression of interest, number and date, page 31, please copy. All right. The bid of the petitioner stood rejected at the technical evaluation stage for the reason of submission of incomplete document. Stop. Document stop. The rejection was communicated to the petitioner with a communicating letter dated 18 September 2025. Stop. The rejection letter clearly mentioned that in case of any clarifications or feedback, the tender inviting authority may be contacted. Stop. A communication from the end of the petitioner seeking clarification with regard to the specific document which were found to be deficient was made on the same date, that is 18 September 2025. Stop. There was no response from the authority. Stop. The instant writ petition has been filed on 14th October 2025. Um, 2025 with the leave of the vacation bench. Stop. The matter could not be taken up during the by the vacation bench, and the same is appearing in the list today. Stop. Next. It has been submitted by the learned advocate representing the petitioner that the person who has been found to be the eligible bidder it has been submitted by the learned advocate for the petitioner that the eligibility criteria of the person found to be the successful bidder.
There are four entities which have been declared successful in the techno-commercial.
Bidders, successful bidders, has been challenged by a separate entity by filing writ petition being WPA 23562 of 2025, cause title, and an order has been passed by the court on 26th September 2025, directing the parties to file respective reports by way of affidavit on the adjourned date. Stuff. The writ petition has been made returnable in the combined monthly list of November 2025. Stuff. Paragraph. According to the petitioner, according to the petitioner. Now, the petitioner refers to clause 7.2.4 and 7.2.5 of the tender document in support of the submission that the evaluation committee at the time of evaluation of the techno-commercial bid could have called for a clarification from the bidder and could have sought for the documents which were wanting so that the petitioner could have met the eligibility criteria. Stuff. The committee did not seek any clarification from the petitioner for clarification of the ambiguities and uncertainties in the bid. Stop. The writ petition has inter alia prayed for a direction upon the tender issuing authority for refraining from opening the financial bid of other bidders in exclusion of the petitioners, and also from proceeding further with the process of final selection of the checkpoint operator. Stop. Next. Learned Senior Counsel representing the West Bengal Mineral Development and Trading Corporation Limited, being the tender inviting and the issuing authority, submits upon instruction that the work order has already been issued in favor of the successful bidder
On 8th October 2020.
on 8th of October 2025. Stuff. It has been submitted that the bid of the petitioner stood cancelled, not cancelled but rejected, as the petitioner failed to submit the
Power of attorney.
it is page 47.
Yes, page 60, page 52.
52 and 63. Failed to submit the power of attorney, format of which was specified in annexure 1 of the tender document. Stuff. There was a requirement of filing the power of attorney by each member of the consortium. Stop. Next. It has been submitted that as the petitioner failed to submit the necessary document in terms of the tender document, accordingly, the petitioner was considered as ineligible to proceed further in the tender process. Stop. Next. Paragraph. I have heard the submission made on behalf of both the parties and have perused the materials placed before the court. Stop. Clause 7.2.4 referred to by the learned advocate for the petitioner specially mentions that the evaluation committee may, at its discretion, ask the bidder for clarification on their techno-commercial bid. Stop. Clause 7.2.5 mentions that the committee may seek clarification from the bidders to clarify ambiguities and uncertainties in the bid. Stop. The submission of the petitioner that the authority ought to have sought for a clarification does not appear to be proper. Stop. Seeking for a clarification was the absolute discretion of the authority. Stop.
He is asking for curing the defect, which is not within the terms and conditions.
আচ্ছা ঠিক আছে the document which was not submitted by the petitioner was required to be mandatorily submitted, and the same hardly requires a clarification. Stop. In the absence of the requisite documents, the petitioners being part of the consortium becomes ineligible to participate in the tender. Stop. Paragraph. It has been brought to the notice of the court that work order has already been issued in favor of the successful bidders. Bidder way back on 8th October 2025. Stop. At such a belated stage, there is hardly any scope to grant opportunity to the petitioner to cure the defect in submission of the bid documents. Stop. Next. In view of the above, the court is not inclined to exercise discretion in this matter. The writ petition fails and is hereby dismissed. Service is taken on record.
I beg to appear, Milord, on behalf of the petitioner. On the last occasion, there was a deduction, Milord, for service because, Milord, some of the respondents did not appear. Milord, we made, Milord, a fresh service. Milord, the private respondent, Milord, appears that she has received. Respondent numbers 2, 3, 4 says that, Milord, the parcel is in GPO.
In?
General Post Office.
Parcel is in GPO. The postal article is in GPO.
Yes.
When did you put it to post?
24th of? Oh, 24th of October.
You cannot expect.
May I come back, Milord? They are, Milord, in Kiran Shankar Road only, Milord. May I serve, Milord, by hand and come back on Monday?
Come back. As long as they are present, the court is all right with it.
Grateful.
Please come. The service of the writ petition and the further notice directed to be served. Video order of the court dated 19th September 2025 has not been effected till date. Stop. Hearing of the writ petition stands adjourned till
Monday, Milord, we can come back. Milord, it's up by today only. Huh? Oh, monthly list, Monday.
10th of November.
Very well. Great.
Stop. Service to all the respondents shall be effected in the meantime.
Grateful to your lordship. But may the
Affidavit of service be written with it, filed in court today be taken on record.
Grateful.
There is a direction to file a exception of the report, my lord. We are filing.
Who is your other side? See, report there on record.
Yes.
File your exception. Yes.
My lord, last occasion, my lord will remember this is Panchayat matter, my lord, where the excess number of vacancy were allotted, and now, my lord, new thing came out. That is in selection committee, according to the notification.
How far can this code go? Because you wanted certain information
Yes,
under
yes.
the Right to Information Act.
But I am
On getting the information, you see there are illegalities.
Yes.
So illegalities has to be challenged before
because
the regular
I am
bench.
before a constitutional court, my lord. It is
There are so many constitutional courts, and
yes,
we have
but
got our
my
own
lord, constitutional
determination.
court have that right, my lord.
No.
My lord,
I
have
cannot
that right,
explain.
my lord. My lord will, because of that, my lord. If my lord wants, my lord,
All information come, you collect the information, you file writ petition challenging the illegalities. Because I cannot,
until and unless because
if you
we
want
pen-
the information, the court will provide.
yes, but they have to give it because of why.
Yes. Do you seek any further information from
Yes.
the authority? What
Yes,
is
my
the
lord.
information that,
That
you
is
want to seek?
first thing is that, my lord, I says my OMR sheet was manipulated, so they ought to place the original OMR sheet. That is first thing,
Yes.
and they ought to send it to the CFSL. Number one.
Didn't they?
But two is that, my lord, because that is my crux of the matter. Well, I not get the information. That's why, my lord, I went up to the State Information Commission. Thereafter, my lord, I filed this writ petition for getting the information. When I got that information in the photocopy, my lord, it seems that there is a manipulation. They give certain document. From that document, it is canvas that there are lots of corruption. Why? What type of corruption?
No, whatever may be the corruption, then what happened?
So, my lord, until and unless I got the original OMR sheet, my lord,
Yes.
how could I access that?
The original has been
Never
produced.
Never produced.
No, now it is here.
Now,
On the last date orders, it's recorded that the original OMR sheet has been produced in a seal cover, and it is retained with the records. It will be open for the petitioner to file exception to the report which you have filed.
the exception.
All right. Now
I gave the copy of the
right. I get it. Now the OMR sheet's genuinity is required to be checked up by the authority.
Yes. It's sent to the CFSL because I
Yes.
says overmarking. Exception আজকে এখন ফাইল করলাম সেটা তো রিসিভ করব আজকে ফাইল করলাম তুমি পরের দিন করবে
আমার স্টেট কমিশন
State possibly will be required.
Yes. একটা কপি
Where is the counsel for the state? Mr. Nilotpal Chatterjee and Miss Protiti Das? Nobody is here?
I can folder এখানেই তো ছিল
Will you come back tomorrow?
Yes, my lord.
Because
but it will be kind enough because I serve the copy exception any day.
All right, please come. Very well.
I serve upon
Exception to the report of the respondent number 2 filed by the petitioner in court today is taken on record. Stop. Let copy of the same be circulated. Stop. Paragraph. The original OMR sheet produced in court. Who produced it? Is it the Information Commission? State. Produced.
Just before district dictating the order, my lord. In my exception, it is supplied by the state authority. Kindly turn page number 40, my lord. Kindly turn page number 40 because that information is also furnished by the state. Page number 40, my lord.
Yes.
This is the resolution for district level selection committee. Here, my lord, got it. Everyone is a member. That is Shabhadi, Poti, MLA. There.
Yes.
One Abutayed, that is Shabhapati Nondigram, is additional member.
Yes.
In the district level selection committee, there is no scope of additional member.
All this will be fresh challenge before the competent
Kindly,
court.
it will be kind enough because there is a specific notification regarding state level, district level selection committee. If they furnish that notification, because I got it from the website 2023 notification. So at that point of time, because according to 2023 notification, there must not be any additional member.
No, but this was in 2017.
2017. So it will be kind enough if they furnish that point of time notification.
Relevant notification.
Yes, madam, that will be kind enough.
ঠিক আছে produced in court by the learned advocate representing the state respondents
There is no scope for additional member.
is already on record. Stuff. Specific contention of the petitioner is that where have you challenged the OMR? Have you mentioned it? That it is not the
exception, in exception, because I got it subsequently.
Yes, exception. Which portion?
Para 8.
Para 8.
Extra shadow. What is one?
But then have you mentioned that this is fraudulent, this is made up, this is
Yes, madam. So such extraneous artificial shadow marking, the evaluation system treated the same as multiple wrong response, thereby invoking negative marking against this erroneous statement has prejudicially affected the score of the petitioner. The said.
Where is the specific line that it is a fraudulent
extra shadow
document?
is, madam. However, the OMR sheet.
Where is the fraudulent document?
That is, madam, from the bottom fifth line of that particular.
No, this I have seen.
Extra shadows.
But then
artificial shadows, madam. And my lord, para 11, I specifically stated,
yes,
does the petitioner herein praise for sending the said OMR answer sheet of the petitioner to the Central Forensic Laboratory, CFSL, and directs an investigation by an impartial agency?
No, that is different.
Yes, yes. Extra shadow, that's why I gave.
A petitioner is that the OMR sheet claimed to be the original one answered by the petitioner has not been marked by him. Stop. The petitioner specifically denies the extraneous and the artificial shadow markings.
Extra shadow.
In the OMR sheet and denies that the OMR produced in court belongs to him. So prayer has been made to get the OMR sheet tested by the Central Forensic Laboratory. Stop. Next. The learned advocate for the petitioner also prays for a direction upon the state authority to produce the relevant notification for constitution of the district level selection committee for conducting the examination selection test, the subject selection test. Stuff paragraph. Hearing of none appears on behalf of the state respondents. Stuff. Hearing of the writ petition stands adjourned till 10th November 2025. Stop. Learned advocate for the state respondents is directed to produce the relevant notification on the adjourned date.
45. Kindly turn page number 45. Recent notification which I got from the website.
No, doesn't matter. This is of 23.
Yes, yes. And there is a no scope of political executive. All are permanent executive. District magistrate, SDO, BDO.
Very well, very well. Elector line, learned advocate for the petitioner is directed to communicate this order to the learned advocate representing the state respondents. Yes, next.
On the matter kept on
10th November.
Lordship, I'm appearing on behalf of the respondent, Bank of Baroda. Lordship, I'm praying for a short passover, Your Lordship.
Who is for the
It's already
petitioner?
been disposed of, Your Lordship.
It has been disposed of.
The writ petition was being disposed of, Your Lordship.
There is an interim application which has come up in the list.
The intervening application has been filed thereafter, Your Lordship.
Thereafter.
So my senior needs to apprise you of.
It has been filed at your instance.
Not yet.
Then
The
filed by the
interveners have
petitioner.
Intervener have filed them.
Intervener has filed. Now who is the intervener?
Tenant, Your Lordship.
A tenant.
Lordship, there's enough alternate remedy and we are armored by the judgments. So
None appears on behalf of the applicant. Stop. Learned advocate representing the
respondent, Your Lordship, Bank of Baroda.
The Bank of Baroda is present. Stop. List the matter in the combined monthly list of November.
Lordship, can
Next.
The 27, I'm led by Mr. Anindo Lahiri, senior advocate. Madam, kindly give me short password, 5 minutes, you will be there. Only
Who is your other side?
other side, my lord, government of West Bengal, they have filed a report on the previous day.
I'll make it only not today.
But kindly give me 5 minutes.
Not today. Yes, next.
There's 28 I for the petition.
I was about to dismiss the writ petition on the last day also when it was called. And then I checked up that it was dismissed. It was recalled at your instance and again you are absent. It was taken up for consideration. It is recorded in the order. See 24th of October. Who is your other side?
I have heard. Thereafter, I also sent another letter also.
Did you inquire from the GP's office who is appearing?
Yes, they have Syed Nozrul. I have given letter they have received, and another by the speed post that have.
Do you know his phone number?
I can inquire. I can.
And the respondent number 4 is represented by whom?
Respondent number 4. That I have sent by speed post, they have received it. I think somebody has appeared.
Somebody has appeared?
Yes, yes.
Please check whether any wakalatnama has been filed by the respondent number 4.
I have sent by through speed post.
It has been filed. By whom? Rohit Mahato. Rohit Mahato.
Rohit Mahato?
Yes. Not Lolit, Rohit.
Rohit. For respondent of 4.
Respondent number 4, yes.
Rohit.
Please check up and serve notice.
Yes, yes, yes.
All right. None represents.
Lordship, I said today I should try to.
And then how will you serve the respondent number 4? You want not today, I'll make it not today. Come back tomorrow. You intimate the learned counsel for the state also. All right, take this back. Only not today. But next time, if you're not there, I'll dismiss it.
I think after vacation, first time matter.
No, it is the order is recorded 24th. Please check up. Next.
For the respondent, my lord, led by Mr. Adar. To 29, I'm being led by Mr. Biswarup Bhattacharya. If Lordship may kindly grant me a short passover.
Why don't you start? Let him come. Respondents are there. Yes.
The respondents.
Is Union of India the answering respondent?
Yes, Your Lordship, Railways.
Union of India?
Yes, Your Lordship.
Yes, yes. You start,
There
let
was
him
a
come.
direction, my lord, to file a report. We had filed a report on a written instruction on the last occasion.
You have?
Yes, my lord.
Yes, taken on record. The copy served issue has been raised by Vidika maintainable to the petition in a contractual matter. Yes, please, what is the matter?
Lordship, I am a manufacturer of railway clips. I had supplied around 24,50,000 railway clips to the railways. There was a time period, a guarantee clause that if they had any issue or wanted an inspection, that had to be done within 24 months of applying it, or within 30 months if they do not use it in that time. Now, after this time has lapsed, they write a letter to me that the goods are defective. I protest to such belated letter by the railways. Be that as it may, as a good gesture, because we have a long-standing business relationship, I replace 50,000 of those clips with the railways.
Out of the
24,50,000.
24 lakh.
Also, railway clips which are used for
Yes.
joining. I have replaced the defective quantity that they have alleged. Now, when Your Lordship, I go and file an RTI. In the RTI, I find out that the entire supply that I had originally made has been used, and the replacement quantity that I have given is also lying with them within the stores and has not been applied. Now, Your Lordship, either they would have to return me the defective goods, which is provided in the IRS conditions, but what they do is instead they issue a notice stating that the 1.74 crores will be deducted from all ongoing contracts. Lordship, I am aggrieved by that order. Since I have replaced it, you at least return me the replacement goods, the alleged defective goods, or do not deduct this amount of 1.74 crores. Which I'll just show your lordships those documents, the two RTI applications. If your lordship kindly takes up my supplementary affidavit. Page 11 of my supplementary affidavit.
Yes.
Lordship will see the first entry. How much quantity out of the set supplied has been laid in track. Full quantity of ERC number such and such have been issued to field units. Now, Your Lordship, the replacement quantity I also ask, page 12.
No, 1 minute. Your query has been laid in track.
Yes, Your
The
Lordship.
reply has been used to the field unit. Has it been laid in the track? If it is defective, how could it be laid in the track?
Concerns the safety of the passenger.
Absolutely, it could not have
Now, Your
been.
Lordship kindly takes the next page at page 12. Whether the replacement supply of 50,000 quantities of elastic railway clips made by JK International, white challan number such and such, have been laid in the track or lying in the stock. If the replacement supply have been already been laid in the
Lying
track.
in stock.
This is the replacement quantity, Your Lordship.
Yes.
Now, Your Lordship will kindly see the guarantee clause. The guarantee clause is at page 16, paragraph point 9, clause 9.4.
Yes.
The guarantee herein contained shall expire in respect of each item of stores on the expiry of 30 months from the date of delivery or 24 months from the date of its placing in service, whichever is earlier, except in respect of defects notified to the contractor prior to the expiry of such date. Now, Your Lordship, my pleading is that I got the first notice on 4th of June 2024, whereas the delivery purchase order was issued on 6th of January 2020. After almost 4 years, I have received this notice. So this is beyond this guarantee period. Be that as it may, as a goodwill gesture, I have also replaced the quantity. So, Lordship, the penalty that has been imposed, since I have already replaced the quantity, there arises no question of imposing penalty on me on the first part. They have issued a penalty on me, and they are deducting from all the ongoing contracts which is impugned before Your Lordship. Nor have they returned the defective goods to me, which they are obliged to under the IRS condition. If Your Lordship kindly takes up the writ petition, page 34 of my writ petition is the IRS condition. Clause 3203.
Page 34.
34 of the writ petition,
Oh, one
clause
minute,
3
one,
to
1 minute, 1 minute. Yes.
3203, Your Lordship.
Uh-huh.
Second part, I'll just read the relevant portion, Your Lordship. Second part, starting from if the contractor or seller so desires, the rejected goods may be taken over by him or his agents for disposal in such manner as he may deem fit within a period of 3 months from the date of such rejection. At the expiry of the period, no claim whatsoever shall lie against the purchaser in respect of the said goods or stores or articles which may be disposed of by the purchaser in such manner as he thinks fit without prejudice to the generality of the foregoing. All the provisions in the Indian Railway standard conditions of contract relating to the rejection of stores and failure and termination at clause such and such. So, Lordship, my reliefs that I'm seeking for is twofold. A, since I've replaced the goods, you cannot impose penalty on me. And B, since I've replaced the goods, at least the defective goods that are lying with the railway should be returned to me. In the report, Your Lordship, there's the document under challenge is page 32 of the writ petition. Wherein, Your Lordship, they have issued this to all the railway zones, around 31 of them, to recover a penalty of rupees 1.7.
Are you delisted?
No, Your Lordship, not delisted.
Since the firm is delisted, they are disqualified for further production. Is it in respect of you or in respect of others also? Recovery Messrs. JK International. You are JK International.
Yes, Your Lordship.
Page 32 mentions the firm is delisted. They are disqualified for further production of ERC MKV5. Adverse performance. More than 3.5 years have passed. That means there must have been a further previous communication for you to replace it.
Yes, Your Lordship, those have been avoided in the writ petition itself.
All right, just let me see the report.
Lordship, only for this particular product.
Please come.
Lordship, may kindly also take note of the guarantee clause, the fact that they have issued afterwards.
The petitioner is aggrieved by the communication dated 8th April 2025. Styled as recovery of penalty amount on account of adverse performance. The petitioner submits that as per the terms and conditions of the contract, there is a particular warranty period. Stop. The petitioner was intimated about the defect in the goods supplied after expiry of such period. Stop. The petitioner highlights that guarantee period. Where did you show me, please?
Lordship, page 16 of my supplementary affidavit, clause
16.
9.4.
16 of the supplementary affidavit. The guarantee period, as mentioned in the contract, lays down that the guarantee shall expire in respect of each item of stores on expiry of 30 months from the date of delivery or 24 months from the date of placing in service, whichever is earlier, except earlier per comma, except in respect of defects notified to the contractor prior to the expiry of such date. As the goods were supplied to the railways in the year 2020 and the intimation of the defect was made in 2024, accordingly, the same is in contravention of the period mentioned in the guarantee clause of the contract. Paragraph, it has been submitted that as a good gesture, comma, the petitioner, a good gesture, and due to the long-standing business relationship in between the parties, comma, the petitioner replaced the defective goods with fresh defect-free ones. Stop. Prayer has been made to direct the authority not to impose any penalty upon the petitioner, as the authority acted in contravention of the terms and conditions of the contract. Stop. Prayer has also been made to direct the authority to return either the defective goods or the goods which have not been used by the railways. Stop. Learned advocate representing the respondents opposes the prayers of the petitioner. Stop. It has been submitted that the items delivered by the petitioner are very vital and essential for maintaining public safety. Stop. The petitioner supplied defective goods and the same was intimated to the petitioner. Stop. The petitioner failed to take back the defective goods despite notice issued by the authority. Stop. It has been submitted that the penal provision has been invoked in terms of the contract. In terms of jaga, in accordance with the terms and conditions of the contract. Stuff. Paragraph. I have heard the submissions made on behalf of both the parties and have perused the materials placed before the court. Stuff. On a perusal of the impugned order dated 8th April 2025, it appears that due to performance failure on the part of the failure of the petitioner, comma, the firm of the petitioner was rejected by RDSO, resulting in the delisting of the firm. Stuff. Because of their disqualification, because of their delistment, they are disqualified for further production. Stop. Now, further production of the elastic railway clips. The fact of delistment was made known to the petitioner, and the defective railway clips were not replaced. Stop.
To be replace the clips.
The petitioner was intimated that the 50,000 clips that the reply supply of 50,000 clips were lying in stock. Stop. According to the railways, poor performance was reported and a joint inspection was sought to be made. Stop. The
In the month of June
petitioner did not cooperate with the process of joint inspection. Stop. The petitioner did not show any interest for providing witness to the testing of the samples collected. The samples were accordingly sent to the samples were accordingly tested in the presence of the railway officials and RDSO officials and were found to be not satisfactory as per IRS specification.
May kindly take note that this joint inspection was only called for in June 2024.
The firm stood delisted for a period of 1 year. 1 year. And the same was communicated with a communication dated 24th September 2024. Following the order of delisment of the firm, the petitioner was directed to deposit the equivalent amount of the failed lot stuff.
50,000 replace করেছো বাকি করেনি 50,000 replace করেছো বাকি করেনি
As the petitioner failed to deposit the amount claimed, the authority took steps to recover the said amount from the other payment due to the petitioner. The railways have already deducted a portion of the penalty amount, and currently a sum of rupees 47,96,773 is recoverable from the petitioner. Stop. Next. It appears that the dispute in question arises out of a contract entered in between the parties. Stop. The subject material, that is the elastic elastic railway clips, are necessary for maintaining passenger and track safety. Stop. The authority has considered several factual aspects, the non-cooperative attitude of the petitioner, and have come to a conclusion that the performance of the petitioner is adverse. Stop. As per the terms and conditions of the contract, there is scope for invoking penal provision. Stop. The authority has invoked the same.
Should may kindly hear me once.
Stop. Next. Whether the penal provision was rightly invoked or not, and whether the petitioner would still be entitled to get back the elastic railway clips, which are alleged to be in the custody of the railway, cannot and ought not railway is an issue which cannot and ought not to be decided by the writ court.
Lordship, may kindly hear me on this point once.
Which point?
Lordship, that your lordships will not exercise your lordship's writ jurisdiction in this on this aspect. Lordship, may I cite only two judgments to that effect?
Yes.
Lordship kindly takes up 2023 2 SCC, paragraph 82.
Yes. 82.
Yes, Your Lordship, paragraph 82 onwards. This is the latest that we were able to find. So it starts from 82, it lays down all the conditions.
Right.
We may call out our conclusions. Your Lordship, the
Which point would you like to highlight?
82.8 and 82.9, the existence of a provision. 82.8 and 82.9.
Right.
Lordship, the existence of a provision for arbitration, which is a forum intended to quicken the pace of a dispute resolution, is viewed as a near bar to the entertainment of a writ petition. The need to deal with disputed questions of fact cannot be made a smokescreen to guillotine a genuine claim raised in a writ petition when actually the resolution of a question of fact is unnecessary to grant relief to a writ applicant. The reach of Article 14 enables a writ court to deal with arbitrary state action even after a contract is entered into by a state. A wide variety of circumstances can generate causes of action for invoking Article 14.
Yes.
So, Your Lordship, even in the writ jurisdiction, Your Lordship, mainly on the fact that there is a disputed question of fact. Lordship, this is I have been relying because, Your Lordship, it is on their own communication that it is relying with them. Lordship, even if the goods are taken to be defective, Your Lordship, I am entitled to return of the goods at least. As per the IRS conditions itself.
Paragraph. এটা এখানে sentence শেষ হয়েছে তো? হয়েছে তো?
And Your Lordship, may I kindly also take note of the fact that a joint inspection was only called for on 4th of June 2024 after a lapse of almost 4 years.
সেটা আমি পরে বলবো। Learned advocate for the petitioner relies
The
on the
inspection relied
judgment delivered by the Honorable Supreme Court in the matter of MP Power Management Company Limited, Jabalpur versus Sky Power. এটাকে copy করবেন। Reported in copy. Paragraph 82. Not no, paragraph 82. In support of the submission that the writ petition will be maintainable even if the same arises out of a contractual dispute in between the parties. And the other judgment that you are relying?
2021 16 SCC.
Yes, give. Reported judgments copies are not required to be circulated.
Your Lordship, again out of good gesture. Paragraph 39, Your Lordship. It relies on ABL International to show.
Yes.
Paragraph 39, Your Lordship, deals with ABL International and says that.
Subparagraph, which one are you referring?
Lordship, I'll just indicate even in paragraph 39.3, 39.2 and 39.3. Till 39.5, Your Lordship, 39.2 to 39.5.
Reference has also been made to the judgment delivered by the Honorable Supreme Court in the matter of Unitech, reported in paragraphs 39.2 to 39.5. ঠিক আছে? Next, the in the instant case, it appears that there is hardly any violation of the constitutional provision, or there is a constitutional provision mandating the writ court, not mandating, requiring the writ court to entertain the same stuff without adducing proper evidence and without perusal of necessary documents, it may not be possible for arriving at a just conclusion to the dispute that has cropped up. The action of the respondent authority does not appear to be arbitrary or illegal on the face of it. Next. the court is not inclined to exercise the power of judicial review in the instant case. Step next. In view of the above, the writ petition fails and is hereby dismissed.
Deeply obliged, madam.
Lordship, I kindly appreciate 4 years after they first call for a joint inspection. Lordship, I'm at least entitled to the return of the goods if your Lordship is not inclined, because that condition, your Lordship, if they are saying it is defective, the IRS conditions provide that you ought to return the goods. Grateful, Lord.
Lordship, under compelling circumstances, Lordship, I am praying for one leave to file one application, Lordship. This is regarding our order passed by your Lordships on earlier occasion for the Market Regulatory Authority. Lordship, violating your Lordship's order, they passed an order and directing the petitioner to pay 20 lakhs within 15 days. And Lordship, and furthermore, some of materials are in transit mode, Lordship. If your Lordships will not take up this matter, even if on next week, Lordship, petitioner will be highly prejudiced, Lordship.
File it in the department. Leave is not required. File it in the department.
Lordship,
It will appear.
Lordship, kindly fixed on any date
You
as per
first
convenient.
file. You first file thereafter.
Lordship, grateful.
29 or 30.
Lordship, appearing for the respondent 1 and 2.
I am for the respondent 3.
Thank
1 and 2 means the Union of India
Lordship, Union and Aadhaar.
and
presence of the
Aadhaar.
concerned bank is required because last occasion there was a direction passed by this court.
Lordship, as per the last order, the bank was directed to furnish the details with respect to the petitioner.
On the basis of my electoral identity card, whether
What has happened? Has the your Aadhaar details and everything?
Aadhaar is not yet to be corrected. For that, but I'm
Very
trying.
recently, I saw it in the newspapers that Aadhaar has come up with another set of rules or guidelines for updating the details.
Lordship, I'm not aware of it, Lordship, right now.
It was just there in the vacation I saw. Right now, what you want the bank to
Bank should update my KYC based on by electoral voter ID card rather.
voter ID card.
There is a circular
Who is appearing for the
officially
bank?
valid document means
The
passport.
bank was represented by the Learned Council.
Yes.
Get hold of him. Will you call and see whether he is there? I can pass it over.
May it please the Lordship, my lord.
My lord, in item number 31, Mr. Devashish is appearing for State Bank of India.
In a proceeding before the learned, the district magistrate under section 14 of the Surface Act, my lord, no notice of the application, nor I was allowed to file a written objection. Principle of violation of principle of natural justice, that is my only case. Because from the
No, what is the position now?
position, because after filing of the writ petition, few days back, my client intimated that they stick a notice board for symbolic possession.
All right. Physical possession has not been taken.
Not been taken.
Right.
I must be candid.
So you go before the tribunal.
The principle of violation of natural justice, that part cannot be looked into by the tribunal. That is my difficulty. Because the proceeding is there before the tribunal. I must be candid.
It is there.
It
You
is
raise all issues. Give me the SA number.
my lord. The number. Petitioner bola আছে। My lord, it is my lord diary number 763 of 2022.
22 diary numbers still?
Yes, my lord.
Why?
That is still pending.
Diary number?
Several dates have been, my lord.
No, SA number should be there. A regular SA number.
No, I have taken instruction because my advocate record is also looking after that matter there also.
Yes.
It is there, my lord.
So it's not a diary number.
It is a diary number, my lord.
Show me any order sheet.
From the order sheet, SA number, that file is not with me, my lord. এতে আছে? আচ্ছা আচ্ছা এটা কি May 25 এটাই 766 মাল May 25 order. Mal, kindly take it from me. It is there. Diary number is still there. Because thereafter it was dismissed and a restoration application has been filed. That is also a diary number. Both diary numbers I can, my lord, provide. I have pleaded in the petition also.
Indian. What is this Indian? 62 of 2025. Miscellaneous application was dismissed for default.
Yes, thereafter an application for restoration, that is also diary number 62 of 25. That is pending. But my difficulty is that, my lord, from the document...
You are not taking proper steps before the tribunal. How does the matter get dismissed for default?
The client... poor person, my lord, is not that well.
That is the reason the advocate is not taking diligence to move the matter.
My lord, it is, my lord, I take the responsibility because
It's not a question of taking responsibility. The conduct of the client is important. Please come. The petitioner alleges violation of principle of natural justice in the steps taken by the bank to take symbolic possession of the secured asset
physical position, my lord.
without serving copy of the application or notice.
Notice given, my lord, notice given. Notice given.
Section 14
Notice given for hearing. My junior was there present.
before the DM.
Before the district magistrate, my lord.
Then where is the violation?
He asked for filing of written objection because the notice before that they issued a demand notice where the amount is totally different.
That is something else.
Well,
You were
no,
given an
well,
opportunity of
Opportunity,
hearing.
my lord, for filing written objection is not given. He specifically, my lord,
That is the prerogative. You challenge the order of the DM. That is something else.
my lord,
Section 14 of Service Act is purely administrative.
Right. It is. You do not have anything to object and
filing
the
of written
authority,
objection, filing of written objection, he was present, my lord. My junior was present.
the authority does not have any adjudicatory power. So what will he do with your written objection?
The application my lord, contains some
Defect.
statement that defects and also untrue statement.
Very well. Whatever is there.
My lord, can you give me liberty so that
No.
My lord,
I can
jurisdiction
challenge?
lies before the honorable hearing.
বুঝতে পারলাম একবার বলতে হবে না একবার বলুন
Without certifying copy of the application or notice.
without certifying without now ওটা লিখুন without granting any opportunity to the petitioner to file written objection.
My lord, he specifically requested for doing so, my lord, prayed for. I have averred so.
Next.
Paragraph RS.
It appears from the submission made on behalf of the petitioner that symbolic possession of the secured asset has already been taken. Stop.
Here is the notice, my copy of the notice.
A securitization application by the petitioner is already pending consideration before the Kolkata Debts Recovery Tribunal number 2.
2.
Being diary number
763.
763. Is it 7 or 17?
7. That's a stroke, my lord.
Bye. That is a stroke. অনেকগুলো আছে Stop. Interlocutory applications in respect of the main matter are also pending consideration before the learned tribunal.
Can you mention the my lord, diary number 62, my lord, so that I can, it will be easier for me. 62 of 25. It's my averment, my lord. Paragraph N, my lord, in the writ petition.
What is IA 1382? There is deficiency.
That was a delay, that is why that I
আচ্ছা
গুলো কেন ছিল?
কেস নাম্বারটা যেটা বললাম না সেটা হবে এইটা
এটা কেন ছিল? This is a delay of what day, 1 day.
ঠিক করে লেখা আছে
ঠিক আছে।
হ্যাঁ
Allow করে দিই।
13 আচ্ছা আর pending consideration before the tribunal including miscellaneous application being number NDN/62/2025. Step next. The petitioner appears to be aggrieved by the order passed by the district magistrate. Stop. This court is of the opinion that as the securitization application is pending consideration before the learned tribunal, it will be open for the petitioner to raise all issues before the said forum in accordance with law. Stop. The writ petition stands disposed of.
We are grateful.
May I get back the order sheet, madam?
Take back. এই নাম্বারটা লিখে নিন ডিবি বাবু, অর্ডার শিটটা ফেরত চলে যাচ্ছে, নম্বরটা লিখে নিন ঠিক করে।
Affidavit of service be kept there. All are
Yes.
সবাই ছিল always.
Item number 32.
I appear for the respondent by admitted that matter where Your Lordship, I appear on behalf of the petitioner. This was my application. Mr. Shuddha Sattva Banerjee was leading me in this matter. Your Lordship, I apologize today, Your Lordship. The client, Your Lordship, we've tried to establish contact with him. He's not been keeping well. May I just pray before Your Lordship to just keep this next week so that we can obtain adequate instructions? Because as per Your Lordship, I am submitting upon instructions today. But Your Lordship, as per Your Lordship's last order, we were given the opportunity to take our stuff out. Your Lordship, the receivables, Your Lordship, with respect to the
what further remains to be
Your Lordship, perhaps nothing, Your Lordship. Just Your Lordship, I am on instructions today because Your Lordship, we've not received adequate instructions from the client with respect.
I can submit on record on instruction that they have removed all that, and it is video.
Please come.
Everything.
Your Lordship,
Please
just stand over next
behalf
week.
of both the parties that the articles of the petitioner have been removed by the petitioners
In presence
and petitioners in the presence of the representatives of the bank, and the removal has been videographed by both the parties. Stop. Next.
Bank has done. I do not know whether
Your
they
Lordship, I don't have
They
any
were permitted.
instructions to that effect.
They were permitted to do it. আচ্ছা, under videograph বলে ওখানে ছেড়ে দিন, by the parties টা ছেড়ে দিন। The learned counsel appearing for the bank submits that the entire recording is preserved in pen drive. In view of the aforesaid submission, the writ petition stands disposed. The bank is directed to preserve the video recording for further reference.
But till 30
Keep
days.
it.
30 days. 60
The
days.
pen drive will remain. Why will you destroy it? You keep it with you, not with the court. So you keep it with you.
Grateful.
I'm for the state.
On behalf of the petitioner bank, my lord, an application under Section 14 of Surface Act was made on 28th of August 23, my lord. The hearing was concluded. The order, we have not received any order.
Your Lordship, there is a discrepancy about the documents we have submitted. The ROR they have submitted is not matching with the land ROR.
Yes.
The loan has been sanctioned.
Yes.
So we have made a letter to them to submit our latest ROR. Once we receive that, we will dispose of that.
My lord, we have not received any letter in that regard.
Please come. এইভাবে একবার চেম্বারে আসবেন, বাড়ি যাওয়ার আগে একবার চেম্বারে আসবেন।
Milord, I am appearing on behalf of the petitioner. Milord, my junior is appearing there. Milord, just the disposal, Milord. Whatever there is, Milord, we will comply with it. Just the disposal within a time bound.
The writ petition at the instance of the bank is for a prayer for from the district magistrate for disposal of the application made by the bank under Section 14 of the Surface Act. Stop. Paragraph. It has been submitted that though the hearing under Section 14 is complete, but final order has not been passed by the district magistrate. Stop. Learned advocate representing the state respondents has obtained instruction from the office of the district magistrate Howrah wherefrom it appears that that a communication vide memo number 8 dated 8 has been issued from the office of the district magistrate Howrah to the authorized officer of the bank requesting submission of certain documents. Stop. Next. It has been submitted that in the absence of the latest record of rights, the district magistrate is not in a position to process the SARFAESI application of the bank. SARFAESI आगे section SARFAESI केटे दिए लिखुन section 14 application of the bank. Stop. Learned advocate representing the bank denies receiving any communication from the office of the district magistrate. Stop. Paragraph. Be that as it may, as it appears that the district magistrate requires certain document from the bank for further processing the section 14 application. Accordingly, let a copy of the communication dated 8 September 2025 be handed over to the learned advocate representing the bank. Stop. The bank is directed to take necessary steps. Stop. On receipt of the required document, the district magistrate shall take steps to dispose of the section 14 application immediately without any further delay. Stop. The section 14 authority ought to keep in mind the timeline mentioned for disposal of the section 14 application. Stop. The writ petition stands disposed of. Are you
I've
sure?
already handed over.
Are you sure that this communication is in respect of this matter only?
Yes, Your Lordship. Because Your Lordship, if Your Lordship can see, it's MS.
It's SM Islam.
Yes, yes, Your
Right.
Lordship.
Where is this SM Islam over here?
Lordship, kindly come to the respond number 5. Sheikh Darul Islam, son of late Sheikh Moshrudul Islam, partner of Majors SM Islam and sons.
So it is in
Regarding
this
this
matter.
matter.
Don't you have any number or something of that sort so that it can tally? Nothing.
I've already handed the.
All right. All right.
Much obliged.
Disposed. Next.
State was supposed to file a report.
44, I would like to appear for the state.
You are for the? All right. State was supposed to file report.
Yes. Because I was the best candidate in the select list. My name is appearing in serial number 1.
Yes.
I was not recommended. Rather, the third man has been recommended.
Third, not even the second one.
Not even the second man. Because of the fact, as I have been informed through RTI, a recommendation of the minister that I have annexed. At page 79.
Report by the Principal Secretary, Law Department, Government of West Bengal, dated 8th October 2025. Placed in court today is taken on record. Stop. On a perusal of the same, it appears that the the writ petitioner was not given appointment as Muslim marriage registrar on the exclusive decision of the Minister in charge of Law and Judicial Department, Government of West Bengal. In spite of the fact that the Principal Secretary recommended the name of the writ petitioner. Stop. As the as according to the principal secretary, comma, the decision of the minister in charge is the final one. Accordingly, appointment was given in favor of the candidate whose name featured in the third position of the select list. Stop. The minister in charge, the reason quoted by the minister in charge for appointing the private respondent has been quoted by the principal secretary, and the same is quoted herein. Copy. Set out. However, it appears from the office record the principal secretary has mentioned that the statute is silent about the question as to whether the role of Qazi is connected with registration of Muslim marriages. And the reason shown by the minister in charge is his personal experience. Stop. Paragraph. Show me from the statute how it is related, how the work of the Kaji and the MMR are related to each other. What is the work of the Kaji?
Your Lordship, I would come to that. First,
The act was given.
the act was given. Rule 3 of the 1929 law.
Procedure for selection of candidate for MMR.
The special reason out of 3, any person could be selected.
Selected by whom?
By the
What role does the MIC have? What role does the MIC have?
I will consider one thing, page 52. This is the notification issued by the principal secretary, which is contrary to his report.
Read petition.
Page 52.
52, yes.
This is issued by the principal secretary to the government of West.
Right.
But kindly come to fourth paragraph.
Oh.
And whereas the state government earlier appoints a Aminul Islam as Qadi of Oripal PS area under section 2 of the Qadis Act 1980, with an order dated 12/9/2023. And whereas the work of Qazi has close proximity with the work of MMR in any specific area, therefore Sheikh Aminul Islam has gained considerable experience in Mohammedan marriage registration related work in that locality. And whereas the state government, on the opinion of the highest authority of approval after consideration of the experience of Aminul Islam as Qazi of Oripal, differed with the recommendation of the district committee Hooghly as well as the recommendation made by the IGR West Bengal to approve the appointment of Sheikh Aminul Islam as also MMR Horipal district Hooghly. This is his earlier notification. This is the notification issued by the principal secretary.
No, this is.
He did not utter a single word, only on the basis of the recommendation of the minister in charge. He has been selected. He has been selected for the experience. His experience has been considered as a special qualification.
By the MIC.
By the MIC, that has not been specifically stated in that earlier notification.
He has stated it on writing.
What my attention is relying on, that is a notification. That is an internal communication. There, note of the department.
Right.
They are also,
Obviously,
here also they have specifically stated due to the experience of working as a Kaji. Because today, if somebody
just show me the work of Kazi and the work of MMR are related to each other.
but both
Experience.
both are related to the process of marriage. Kaji can might not perform the rituals, but he cannot only the register the marriage. The MMR have the power to register the marriage. Now today, if an MMR appointed in that particular area, then he will conduct the entire thing. The Kaji have no role to play, my lord.
This is like my Purohit, like conduct the rituals part.
Now, I'm working as a Kaji since 2023, so my experience has been taken into consideration as a special reason.
How can the Kaji have the experience of registering Muslim marriages?
My special criteria is he should have his knowledge about the Muslim rituals which is required to be performed at the time of marriage.
Nothing to do.
Anyway, that is different.
That is the reason, madam.
There are two acts separate governing the field. Separate acts. What is the requirement of?
If I may just assess this.
Not been defined in rule. For any special reason, out of three, anybody could be selected.
So if you, no question of challenging the rule. Now, if the minister has come to an opinion that the Kaji is enough, he can act as the registrar. What is the use of having a different act? That is what he has done.
That is not the requirement of the act.
That is what he has done.
Experience has been taken into consideration. Not on the basis of the recommendation of the minister have been selected.
It is at the recommendation of the minister.
Because kindly come to the notification.
Because the recommendation is of somebody else.
Kindly come to page 70.
No, wait. What are you submitting?
As per 3A, if I may place the entire section, if I may be allowed to place, on occurrence of a vacancy in the post of a Mohammedan registrar or on the creation of a new office, rules 1929 rules. Your Lordship has a copy of that?
Yes.
On the occurrence of a vacancy in the post of Mohammedan registrar or on the creation of a new office in any district other than the district of Calcutta, the registrar shall once make temporary appointment to carry out on the work of office, intimate the vacancy to the Inspector General of Registration and invite applications for the permanent post. Applications may also be received by IG of Registration, but on receipt, he should forward them to the registrar of the district concerned. The registrar will then send to the IG of Registration all the applications for the post after recommending in order of preference the best 4 of the application and merely noting on the others not recommended.
So one thing, the registrar, what is his work? He forwards the application to the IGR.
That thing.
Let us go step by step.
He will then communicate the recommendations to the government, who may select one out of these. The 3 names for any special reason may select any other from the rest of the candidates. Now, Your Lordship, if we consider the Muslim Marriage Registration Act and the Qazi Act, there is no specified bar that such person with Qazi designation or MMR designation cannot be appointed as vice versa as a Qazi or MMR. So that bar is not there in the statute. In my humble understanding,
there is no mandate either.
No,
that
there is
one
no mandate.
is a Kaji.
But why
he has
this,
to be given
this person,
preference.
Private respondent has been considered. This thing has been taken into consideration as a special reason. There may not be a mandate, but this is the special reason as my humble understanding goes. Rest, Your Lordship, I cannot go beyond this report because the minister's notification, the minister's note or minister's decision is this much only.
Can the recommendation of the minister in charge be treated as the recommendation of the government?
State. That's my point. That's
Your Lordship, that we will have to, in this report, the minister's decision
now,
has been acted upon.
That is all right. But show me from law whether the minister is the government.
It is not. It is my humble understanding. It is there is a difficulty. That's why this report has left it open to the honorable court.
Yes.
As
How do you overcome this difficulty?
Lordship, that is there.
That is there.
There is no
private respondent.
explanation to
The
this.
minister is the government.
That
No.
I never, I will not say this.
Not say
but
this.
my lord, kindly appreciate one thing. In his notification on my lord 3/6/2025, that is at page 52, he must state that he has been, this private respondent has been selected only on the basis of the recommendation of the minister. And it is the employer to decide what would be the special criteria for which he could be. It is not the case of the petitioner that I don't have.
The employer is the state government. Employer is state government.
State
Here, my lord, employer does.
Right.
Here, he
Now,
is not a
selection
salaried
committee is not the employer. Employer is the state government. No, the state government has recommended X's name. The minister has recommended Y's name.
But there should be a selection committee who can consider, because the name has been recommended by the
No,
district
if these
register.
are not there in the selection procedure rules, these cannot be imbibed at this point of time. The thing which has happened is, your lordship, it has gone up to the principal secretary, then it has moved up to the minister in charge. There lies the confusion. For this, a new rules or something,
And
that
my lord, kindly
is
come to
vacant.
page
There is no rule of
46. Here,
the.
everybody's name has been recommended by the political persons. Kindly come to page 46.
Thing is, without the blessings of the political leaders, nothing happens in this state. What can be done?
That is the difficulty. That is the procedure now going on.
If this is the procedure, then the court has to follow the law. The court cannot proceed with the procedures that is prevailing.
It's not that I have been selected only for the recommendation of the minister.
It is.
Selected for the my experience, which has been taken into consideration.
Your experience was there before the selection committee. Your experience was known to the principal secretary and the other members and everybody. They did not find any reason to give special preference to you because of your experience. It is only the minister who comes in and says, no, he is a Kaji and he has got experience.
Ultimate decision taking authority.
Who is the ultimate decision taking authority? According to law, it is the government.
No, madam, kindly come to page 46.
The law rule says it is the government. Then how do I take into consideration the recommendation of the minister in charge?
Madam, minister in charge or something not recommended by him. Well, come to madam, page 79. What I am trying to apprise that only my experience has been taken into consideration. And madam, kindly come by relying upon one judgment, that is 2019 volume 6 page 362. Which says it is for the employer to decide what to be the special criteria.
No dispute. The proposition.
And here the employer has decided my experience.
Who is your employer?
State government.
That's the
State-
point.
Page
I believe the secretary of the department is fair enough, my lord, to
Yes, he at least came up with proper facts and said that this is the problem. And he couldn't do anything despite the recommendation given by the committee and the secretary and everything. Please come.
that would be reflecting from the records also that we have next. One more thing, I can kindly record that the
And
it
last
should not be compromised for a special reason, because I have obtained 4.125 marks, whereas the third man obtained 2.375.
Show me that.
page 59.
No, that is, in my humble understanding, it's much for the asking your lordship, there is no concept. As per 3A, special reasons is there. He has to add.
Yes. Yes.
So whatever is special in must be
4.125.
because and 2.375 third man. And the specialist reason must be read, keeping in mind the principle of wisdom generis. The Purohit cannot be appointed as marriage register. That's a can be provided he has qualification in terms of the yes.
ওই তিনজন নয়, তিনজন ছাড়াও আমি অন্য কারো কিছু করতে পারি। Top mark তিনজন ছাড়াও
আমি দেখেছি there is something that should be challenged. না না হুম? আমি ছিলাম না আমি ছিলাম না।
Everybody must be having this page 59 in the writ petition. Please open this and let us read 3A once more.
PA.
Right? And see
Your lordship is referring to.
59. There is a chart.
Yes, yes.
Right? Let us look at the headings. From the left, it's serial number, name of the applicants, residential address, residential proof, educational qualification, marks, and the recommendation. And see the recommendation portion, the number of political leaders recommending.
That your lordship is.
That is the requirement of advertisement.
Is it?
Jurisdictional, yes. Local person has to be.
But the procedure does not lay down any recommendation portion. Where is it? It is only to be recommended by the registrar. The order of preference. Where is the question of recommendation from political leaders? Show me that.
Just a second minute. Recommendation of the register.
The advertisement.
Recommendation of letters.
Does it?
Paragraph
Applications are
my
invited.
application.
Possessing sufficient acquaintance with the Arabic language, Mohammedan law, marriage and divorce, having good moral character.
Paragraph 12, page 24, clause 12.
1 minute. Educational qualification, experience working as MMR, residential certificate, proof, character certificate, voter card, Aadhaar card, passport, ration card, any other testimonials required.
Clause 12, page 24, clause 12.
Name and address of the person recommending the candidate. Where from has it come?
This is the pro forma given with the notice.
Rule 5 in the Mohammedan rules. Let us see Rule 5 once.
Rule 5, to me, yes, there is no
Form.
I don't find at least.
Candidates are required to moral such and such.
Yes. And receive the application.
In the rule, there is no such thing as recommendation.
I didn't find.
No, 9. Name and address of persons recommending the candidate. Names and address of the persons recommend if previously appointed, if ever dismissed, particulars. Address of the persons recommending the candidate.
Not the same. In fact, if you is kindly find from the
No, from the rule it is there. 9.
Rule 9.
5, 9.
5, 9. Yes, sir. In fact, the same MLA is recommending other candidates also. Snehashish Chakraborty, first recommending first man. He is also recommending 60, serial 7.
It doesn't matter.
Serial 7. Serial number 7.
That would not add
Becharam
much
Manna,
to the
Becharam Manna, the other MLA, local MLA, he is recommending 1 and 3 both. These are
and PA allows your lordship the government to choose from the recommended or from unrecommended ones as well. the language of 3A is such. So this recommendation portion is not very much troubling us, I believe. It's just that the decision which is troubling.
The decision should be on merit. And in fact, the marks given based on my academic credentials.
You have the rules of business of the state. Do you have the rules of business? What exactly the state government mean? And
That
how
you
much?
can find from the constitution, lad.
All right, you've got a separate rules of business, right?
I'll have to inquire and talk.
Yes, please come back. কতদূর বলেছিলাম বলে তো ডিবি বাবুকে? হুম 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 right. As according to rule P within brackets small a of the rules relating to appointment of Muslim marriage registrars and the procedure for selection of candidates as laid down therein, comma, the on occurrence of the vacancy in the post of a Mohammedan registrar,
No.
comma, the registrar shall at once make a temporary appointment to carry on the work of the office, comma, intimate the vacancy to the Inspector General of Registration and invite applications for the permanent post. Stop. On receipt of the applications, the registrar will forward the same to the Inspector General of Registration after recommending the order of preference the best 4 of the applications and merely noting on the others within quotes not recommended. Stop. On receipt of the applications, the Inspector General of Registration is to ask the permanent committee, PC caps, to consider them along with his remarks and the remarks of the registrar, comma, as the case may be, comma, and submit their recommendations putting forward 3 names for each vacancy in order of preference. The recommendations are thereafter required to be communicated to the government, who will select one out of the three names, or for any special reason, may select any other from the rest of the candidates. Stop paragraph. In the instant case, it appears that the principal secretary
Basically, secretary of the respective department.
issued the notification of appointment of the private respondent solely relying on the decision of the minister in charge, who took into consideration the experience gained by the private respondent for acting as Kaji. Stop. Whether the decision of the recommendation of the mayor and council could have been given so much of weight for providing appointments to the private respondent, despite the private respondent obtaining far less marks than the first recommended candidate, and whether the act of functioning as Kaji can be treated to be and whether the act functioning as Kaji can be treated to be a special reason for recommending appointment of the private respondent is required to be adjudicated by the court. Stop. The parties are directed to come ready for arguing on the above issue on the adjourned date. Stop. When do I fix it? I would like to see the rules of business. Please bring it. All right.
Next week, ma'am.
Next week. 7th of November.
Your Lordship, can it be kept on 10th or 11th?
10th is a Monday. I do not want to block it.
Any day.
7th, you have a difficulty? 14th of November.
14, any day before 14, 14 I have some. That particular week, I will be out of state
Entire week?
due to treatment of my mother.
Then can it be on 4th, 5th?
5th is a holiday.
After 14th, Your Lordship.
After 4th, 5th is a holiday.
14th, after 14th.
After
Or
14th?
maybe on 12th, 13th, anything.
No, he won't be there.
Before 14th.
See, it's very difficult to find out a date in that case.
This week? Are you going to be able to-
Friday?
Till today, there is holiday today or day before, yes. So we will have to. And honestly speaking, Mr. Mandal is leading us in this matter. He is in bed rest due to his eye surgery.
21st of November.
Let it will be treated as part-hard millet.
Sorry, sir, I cannot do it. I never do it. Never.
Because they have argued a lot, not me.
Whoever, the court has spent some time on this matter.
21st, 22 and 24th. I will be out of station on that particular week due to treatment of my mother.
Of this year or
But then you said you won't be there from 10th to the 14th?
21, I will be out of station.
14th to 21?
Oh, Baba.
Then in that case, prior there too, we can keep it.
Prior 14, I have no difficulty.
12th, we'll keep it in that case. 12th.
কি হবে না না?
Yes.
At the outset, I would like to apologize for not being here at the time of call. I was on legs in a different courtroom.
Good that you were engaged. What is your instruction?
My instructions, though I have sought for it in a written format, so it will be easier for my lords. The Aadhaar card that was initially there is already on the system for our KYC.
All right.
Any document that we upload, either virtually or physically, that is that comes with a mismatch, we are not allowed to upload. The issue is that we are
That means right now what is to be done is to tally the Aadhaar with the Epic.
Yes. Or Milord, if the Aadhaar authorities say that you do not need to go into this because this is a imposition given by the Aadhaar authorities, the entire KYC situation is an imposition given by the Aadhaar authorities on the respective banks. If they
So, that means right now you do not have any scope to disregard or ignore the Aadhaar and to proceed with
for the purposes of a KYC only, not for the purposes of a operation of accounts.
Yes.
And Milord, the necessary implication that follows is there is a 12-year age difference. And the difference is senior citizen and not senior citizen, which is another 2.1%
interest rate.
Or if not more. And Milord,
Yes. No.
And Milord, in the event an interest has to be garnered into her account on the basis of an additional percentage basis that she is a senior citizen, and then tomorrow if the Aadhaar authorities say that look here, this is not the situation, then again proceedings will be we cannot automatically deduct. I have personally told my clients to not go into that situation. So
yes, I've got it.
From his blood notification blood.
His means banks.
Bank. RBI. Blood officially valid document for KYC that includes blood passport, blood voter's identity card, Aadhaar.
No, but what
driving license
submitting is that your Aadhaar is already there on record, and the moment they find a mismatch, they cannot register your KYC.
And neither can I give preference to one instead of the other.
And the age difference is 12 years. The mismatch, the period of mismatch, had it been a day or two, 1 month, 1 year, is different.
If I may be allowed to withdraw my Aadhaar until it is corrected, so for the date of birth is concerned.
This is what I was inquiring, whether this can be permitted, and the bank says no.
It's not under my control. Only the uploading is under my control.
But that
Why
process,
why are you not getting the?
I'm trying to correct it,
Yes.
In fact, I have instituted a suit, possibly, or going to be instituted a suit, because that's the only way I can correct it. I have inquired into. Otherwise, there is no other.
The authorities are not acting. You have to go to the suit court for getting relief.
That process is on. And possibly
That will take time. You cannot get it done now.
that is the only way, Mlad. I have checked, Mlad. I have inquired into from the KMC also, Mlad. They do not want to, Mlad, correct it, Mlad, because
It cannot be done. It cannot be done. KMC cannot correct it.
They also
through a
saying that
photo
they are
or something.
permit it.
Yes, the court's order is required, and a lot of things are required.
So it's a better way to go for suit, and
In that case, I am not proceeding with the writ petition any further. Let it remain pending. You take orders from the suit court and get it done, or I can dismiss it right now. You file fresh petition.
Mlad, that's what I'm saying, that so far Mlad, KYC is concerned, in terms of RBI guideline, they can.
What they can?
That instead of Mlad, insisting on Aadhaar, they can rely on other documents. That is there in the rules.
How can they ignore one document and place reliance on the other?
Aadhaar was not there from the beginning.
May not be right now. The KYC will be updated today. So whatever the rules is available or applicable today has to be applied by the bank.
That rules permits me to Mlad, file my other documents. That is there in the rules, RBI rules.
To file your Aadhaar documents,
No.
file it.
Other documents.
Other documents. Yes. But in the meantime, your previous document is uploaded in the system.
That can be Mlad, withdrawn.
Not according to your
Mlad,
No, sorry,
this
sir.
process can't
Please
be
come.
mechanical, Mlad.
In the
Or
in
else,
the
Mlad,
interest of
kindly adjourn the matter, Mlad, sign it until Mlad, I am.
in the interest of the writ petitioner, my lord,
Yes.
I say two things, my lord.
Yes, please.
One, with respect to the interest percentage, the bank is apprehensive that the senior citizen age and the interest will be kept in a suspense account. I have kept that. Second, my lord, this is completely, my lord, not of the situation, my lord, that if the writ petition is disposed of, they will not get any credence from the authorities. Any credence or importance from the authorities with respect to them pursuing their remedies.
What type of credence you want?
My lord, if they cannot show that there is a dispute pending, they will not be able to come and kindly does not take me amiss, my lord, but the situation will be such that they will be caught between the deep sea and the devil.
I will record you. I will record that you will keep the interest part separate as you are keeping it.
Yes.
As
That I have
regards
already personally given. Yes.
Right. As regards the petitioner availing remedy before the suit court for correcting
Yes.
date of birth, and that is separate.
Yes, kindly, my lord.
That the suit court will
Then the bank
act
will have
according.
yes.
Then the bank can.
Then the bank will have a stronghold to keep the interest aside.
This I will record.
Kindly record that I have personally instructed them to keep the
Thank
interest
you.
aside.
That's Upon hearing the submission made on behalf of all the parties, it appears that the petitioner is yet to amend the details in her Aadhaar card. There is a mismatch of the date of birth of the petitioner recorded in her EPIC and Aadhaar card. The difference of age is approximately 12 years. Without the proper date of birth, the bank will not be in a position to ascertain the quantum of interest to be paid in favor of the petitioner. The petitioner is already taking steps to rectify her Aadhaar card. As and when the same will be rectified, the petitioner may file the same before the bank for taking further necessary steps for registration of her KYC stuff. Till such time, the petitioner produces documents documents.
Or orders from jurisdictional court.
Documents in support of her proper date of birth from the competent authority, comma, the bank is directed to keep the interest meant for senior citizens in a separate account. Stop. Currently, the petitioner shall be paid the interest
Banking interest.
which is applicable to the regular customers and not the interest meant for the senior citizens. Stop. Any further direction? No?
If I have to just record the differential interest.
Differential interest.
That's ordered.
All right. No, the next line I have clarified it. যেখানে উপরে লিখলাম না ইন্টারেস্টটা differential interest. Otherwise, it is all right. The writ petition stands disposed of. Yes. এই জায়গাতে একটা লিখেছেন আপনি। Will they keep the interest aside? They have a differential interest aside.
Item number 341.
341? 341? 341 হয়ে গেছিল না? জানা বাবু?
This matter will be the conflict.
এক মিনিট শুনুন।